All rise. The justices of the Appellate Division, Supreme Court First Department. Introducing all persons having business with the Appellate Division. Join here, your attendance, and you shall be heard.
Good afternoon, lawyers. We have several hours, 5 hours, I understand, of requested argument time. As you've heard me often say, please ask for the time that you need, not the time that you want. We have read the record, we have read your briefs, we're quite familiar with the underlying issues involving these appeals. So you may think you want 15 minutes, but trust me that you don't. So I'll begin with a call of the calendar. People versus Brandon Brown. Okay, submitted. Certain underwriters versus 47 Fifth Avenue. Okay, 5 and 2 for 47 Fifth. Certain underwriters.
Mark Binsky, Colonel Abrams, Royal Freeman, Jacobson, Hawkins,
How much time do you want?
also 5 and 2.
5 and 2. Do you have a cross appeal?
No, so I'll just take 5 and 1.
Okay. If you can keep your voices up, I would appreciate it.
Alexander Papa promoted the allegations of David Myers and duty for third-party defendant respondents, Jose International Inc. and Roman Alabama Diamonds Limited. 2 minutes.
Okay. M. Children, thank you, folks. M. Children is submitted. Menlo Energy Florida versus Loy. Appellant. Appellant Mays, 5-2. Respondent? Can't hear you. 3 minutes. People versus Soto.
Appellant, 4-1.
Appellant Rojas Soto is 4-2, you said?
4-1.
4-1. People?
For respondent, 4 is fine, please.
Okay. Connor versus AMA Consulting.
Appellant request 5-2, Your Honor.
5-2 for appellant.
Respondent Jamestown, request 5.
Okay.
AMA request 3.
And, okay.
Respondent TF Nugent, just 1 minute, please.
Okay.
Respondent NLB, request
2. You did the addition on that? 14? Okay. So 5-2, 5, 3, 3, 1, and 2. Thank you. Yankee Foot Locker.
Good afternoon, Your Honor. Bernadette Canzella for the town Chunky. I'm requesting 8 and 5.
What and 5?
8 and 5?
Okay. I'll give you 8 and 2. You won't need all of that time, trust me. Either there is successor liability or there isn't, right? So, but we'll get into the details later. 8 and 2 is fine. Respondent Full Locker?
For the respondent, 7 minutes.
8 and 2 and 7. Dumbia versus Bamba is submitted. SSP Springs versus First Specialty Insurance. SSP Springs.
On behalf of the plaintiff, appellants,
5 and 3, and cross appellant First Specialty.
6 and 2, please, Your Honor, and I'm here also to introduce my colleague who's here for PJ.
Okay. I read the application, so that application is granted. I know you're anxious to get back to your firm, so. So what was the request, 6 and 3? 6 and 2. Okay, 5 and 3 and 6 and 2 for cross appellant. Senani versus Casandler Family Trust.
Jerome Zanani, the appellant, on request 82.
Okay.
For the respondents, 5 minutes.
Okay, I tell you what I'll do. For petitioner Senani, I'll give you 5 and 2, and then 5 for responding. If we need more time, we don't have a Yankee game tonight, so we can go all night if that's what you want. Trust me, you don't want that. But I keep saying it. People versus Soto is submitted. Maldonado versus Liberty Elevator. Petitioner, Appellate Maldonado. 6 and 3. Liberty Elevator responding? 5. PCT Contracting versus Rick Disler.
Plaintiff, appellant, respondent, 5 and 2.
5 and 2 for PCT. Cross appellant Rick?
Yes, 5 and 2, please.
5 and 2. Okay. Ellis versus JP Morgan Chase Jones Lang ABM. I can't hear you. 5 and 2.
Appellant Joe Slang LaSalle, 5 and 2.
Cross appellant.
Appellant Chase Bank, 5 and 2, Your Honor.
Thank you.
Third party defendant respondent, 4 minutes.
And 4. Okay, and then People versus Letitia James. I'm sorry, Letitia James versus Trump Organization is submitted. Jones Day versus Serenity Pharmaceuticals is submitted. First case on the calendar is certain underwriters versus 47 Fifth.
Okay, thank you. Good afternoon, Your Honor.
Give them a second, they
Oh, we
seem
need
to be
another.
smiling and. We ready to go?
Thank you.
Okay.
Jessica Erickson from Cozen O'Connor, representing the defendant appellant, 47th Fifth Company. This appeal really comes down to essentially one phrase contained in the Lloyd's of London policy, and that is the last portion of the waiver subrogation clause, and stating, "and/or persons or companies, including but not limited to banks, armored car carriers, entrustment holders, private clients, security companies, auction houses, and/or gemological laboratories." With respect to the lower court's holding on this, it found that this encompasses a very narrow class of persons and entities, being carriers or wearers of the jewelry which was being insured under this policy. However, this phrasing here is actually an expansive application versus,
So you don't think persons or companies is narrow?
I'm sorry, Your Honor,
Persons and companies is a broad category.
it is a broad category, but the way that it was interpreted by the lower court, it was very narrow. In fact, the court actually joined this phrasing with the one that comes before it, which was the persons authorized to wear and carry the property. Those are two separate categories of individuals for whom this waiver of subrogation would apply. And the second category, the one which is at issue here, does not pertain to wearers and carriers, and in fact, even the...
And it's your position that it doesn't relate to what comes before because of the phraseology of "and/or"?
That is correct, Your Honor. That is a disjunctive phrase. It separates the clause into different categories, and I believe that the lower court did miss this disjunctive when it interpreted this clause. And also, if there is a string of words, which we dispute because it does say, but not limited to, these types of entities are not just wearers and carriers of jewelry. There are other entities involved here, including banks, etc., which are not wearers or carriers of jewelry, which would also then encompass the landlord to whom the tenant entrusts to house their jewelry store, and thus the jewelry that's contained within that store, the merchandise. So this waiver of subrogation, we believe, does apply in this case, and pursuant to the contractual terms of, or the lease agreement, the waiver of subrogation provision contained in the lease agreement, this should be read into the, and be applied in this case, therefore dismissing the subrogation claims which have been brought against the landlord for the loss herein. If there's no further questions, that is actually the crux of my argument here.
Okay, if we reinstate that waiver of subrogation, the second order is moved, right?
That is correct, Your Honor. That is correct.
Okay, thank you.
Thank you.
May it please the court. My name is Mark Binsky with the law firm of Abrams, Gorlick, Friedman, and Jacobson for the plaintiff appellant. I also represent I'm sorry, for the plaintiff's respondents. And I also represent M&G Diamonds LLC and Roman Malakoff LLC. And I mention that only because there was, in passing, an argument was made by the appellant that I had no standing with regard to the third-party defendants. But in fact, I do, because I represent two of them.
Okay, I mean, let's focus on the plain language of the waiver of subrogation clause, which the landlord interprets as permitting their waiver of claims against persons or companies, which would include 47 Fifth, right?
That's their argument.
Tell me why.
Well, I don't think it does include 47 Fifth, because 47 Fifth is the landlord, and
It's a company, isn't it?
it is a company, yes.
So doesn't that get covered by persons or companies?
Well, I would submit to the court that it doesn't, because the
So
clause...
companies doesn't include companies.
No, companies
Tell me
includes
why.
companies, but the companies have to be of the type mentioned in the waiver clause, which is only companies that, well, in this case, you have, the company has to be entrusted with the jewelry that is owned by the Malakov jewelry store.
Why is that? I mean, first of all, the language of the, as it appears at page 125 of the record, the waiver of subrogation clause, the phraseology of it is broad language. I mean, this looks like it's meaning to be inclusive rather than exclusive. But there's also and/or, each item, each entity that's mentioned is separated by this and/or. So I think
Which you drafted.
which of course is the further point, which is you drafted this, so if there's any ambiguity in this, it's to be construed against you.
Well, Your Honor, I don't believe that there is an ambiguity. I think that if you look at the clause in its entirety, it is meant to authorize subrogation waiver against only a limited amount of companies and persons. And that limited amount is defined by people or companies who are entrusted with the jewelry or who wear the jewelry. Now, of course, my adversary mentioned that banks don't wear jewelry, but that's really a straw man argument, because banks can be entrusted with jewelry as collateral. So the clause, I think, taken in context and as a whole, means that there can be subrogation waiver.
So you're interpreting this and/or persons or companies as referring back to wearing or carrying the property. Is that what you said?
That is correct, Your Honor.
So
Well,
if
why
that's the
should one
case,
Go ahead.
Go ahead, David.
Why should one make that sort of an interpretation? Why shouldn't it be looked upon as just another category of people or entities that you can agree to enforce or not enforce?
Well, because it says against customers and/or persons authorized by the insured to wear and/or carry the property insured on their behalf. It clearly links...
And/or persons or companies.
And/or persons and...
Companies, why
Yes.
isn't that connected to the phrase which follows, including but not limited to banks, armored car carriers, entrustment holders, private clients, security companies, auction, including but not limited to? Again, that broad language. I mean, why isn't that phrase looking what comes next in the paragraph, and you've got including but not limited language, which is, again, this broad language, which if there's an ambiguity, it's against you.
Well, the principle, the general principle here is when you have a series of words that share attributes, and then you have a word proposed to be included in that series, the word proposed to be included in that series has to share those attributes. That's
Why do you
the-
list persons twice? Why is persons listed twice? Why is it stated twice?
Well, because the clause introduces the broad concept, which is we will allow subrogation waiver against people that carry or are entrusted with the jewelry, and then it gives certain examples.
So my other question is something that was brought up earlier. You drafted this. If that was the intent, why not simply say that? Why not simply say that you're only talking about persons or companies authorized to carry the product?
Well, I believe it does say that, and then it gives examples of those types of people.
No, it doesn't say that, because my question is, why would it simply not say, limited to waiving claims against persons or companies authorized to carry the products, period?
There are many ways to express ideas, Your Honor.
Well, yeah, the
Well, yeah, but-
clear ways and ambiguous ways.
Exactly.
Well-
And so that's the whole point. You want it to be unambiguous, right? And so since you're drafting it and you want there to be you don't want there to be an issue, then it would seem to me that the simplest and the most unambiguous way to express it would to simply state it that way.
Well, Your Honor, I would draw a distinction between a poorly worded clause which still makes the point and an ambiguity. I think this clause is the former. It may not be written like poetry. It may not be written with eloquence.
Clear
but it gets
prose
the
would
point.
do.
Well, Your Honor, we have what the clause is meant to do is to state that subrogation waiver only applies to people entrusted with the property. It then gives a number of examples, including the landlord in those examples just doesn't fit.
I got your point.
And if you look, why have this clause if you're going to extend subrogation waiver to the whole world, which is essentially what the appellant's argument is? Why would the clause take pains to say we're only going to have subrogation waiver against people entrusted with the property, then give examples, and then open up the waiver to everybody in the world?
Thank you, counsel.
Thank you, Your Honor.
So, 2 minutes.
Good afternoon, Your Honors. On behalf of third-party defendants, respondents Elizay and Roman Malikov Diamonds Limited, we solely put in papers in regards to the amendment to the third-party action, which defendant appellant sought. They sought leave to amend the third-party action to allege a breach of contract claim for failure to obtain this enforceable waiver of subrogation provision. Just simply a reading of this lease agreement, in particular Article 9E, there is no requirement that Elizay or Malikov Diamonds Limited be required to obtain an enforceable waiver of subrogation provision in favor of landlord. There's clear conditional language within that provision that states that unless both parties obtain such a provision, that is the only way for the waiver of subrogation to be applied. There's just no requirement based on the plain language of that lease stating otherwise. Thank you, Your Honors.
Thank you.
I'll be very brief, as I just want to address one point. Counsel had mentioned that if this is interpreted broadly, that it would just apply to basically anyone in the world. However, it is subject to the lease agreement wherein these parties agreed to this waiver of subrogation provision. It is not just anyone, it is someone that they specifically contracted with. And subject any other questions by the court, I will rest there.
Yeah, I think we're good.
Thank you, Your Honor.
Thank you all. Menlo Energy Florida versus Lloyd.
May it please the court, William Costigan for the plaintiff appellant. Oddly enough, this case also involves an awkwardly worded Lloyd's of London policy. The court below erred in strictly construing the BioPro policy at issue in this case, strictly construing the loss notification clause to forfeit Menlo's coverage. This appeal from summary judgment is before the court for de novo review.
I mean, the notice provision is a condition precedent to liability, right?
That's
The notice to underwrite it did not occur until September 14.
It occurred 51 days after the notice of loss, yes,
Right.
September
So it's
14th.
inside the 60 days. The
Correct.
question is that as soon as practicable?
2 points there, Your Honor. First, it appears that this clause is really just a clumsy amalgamation of 2 clauses. One that says give notice as soon of a loss as soon thereafter as practicable, and another one that says give notice within 60 days.
So if in fact you only read the within 60 days, what is the purpose of the first clause stating when and if practicable?
Correct, and there is one logical possibility, but it would apply only in a rather strange scenario. That would be one where it is not possible to give notice within 60 days. And in that case, the second clause, and these are only separated by a comma, but the second clause would forfeit coverage even then.
So are you saying that the 60 days provision sort of defines the other clause that requires as soon as practicable? And it's only because, I mean, soon as practicable is just citing First Department and Court of Appeals language with respect to when the notification needs to take place. But they will define it by saying the ceiling is 60 days.
Yeah, I think that's exactly the way the average insured would read that. And the vigilant case.
Why do you say that? What authority is there for that position? I mean, this clearly calls for you to give notice as soon as practicable, and the 60-day, and in any event within 60 days, you're reading out the as soon as practicable language. I mean, it becomes surplusage then. You've just got 60 days.
Well, what the vigilant case says is to view this from the reasonable expectation of the average insured. I submit
But wouldn't
that
you
when
say
they
that the
read
reasonable expectation of the average insured is that if they know that there's a problem with their machine, which they feel is covered by insurance, that they're going to tell their insurance company, and they're planning to make a claim about this to the insurance company, that they know that they have to give, these are after all sophisticated parties, they know that they've got to give notice to their insurance company, and that they would do that as soon as they're planning to make that claim, and not wait, as is the situation here, that you've repaired the problem before the insurance company even has an opportunity to come down and inspect the problem.
Well, I respectfully submit that Menlo, which is a small environmental engineering company, is not a sophisticated party. The plant manager here has a high school education. They had this policy. Buried in the small print is this awkwardly phrased loss notification clause. And I think the expectation of the average insured would be, I have 60 days. Be that as it may, if I leave...
So you had 60 days, so you knew by July 25th that the vacuum blower was excessively vibrating, right, and leaking at the seals.
And there had been an event, a gear and head plate getting broken by an impeller.
Right, so you knew that if you lose that vacuum blower, it's over, right? You're going to be out of business for a while.
Yes, and what we could not know on July 25th was how quickly how long that problem was going to last.
Okay.
And I would add, there's a 10-day deductible period, so our business interruption insurance doesn't even begin until after 10 days.
Okay.
If I may make one
Yeah,
last
no, I'll
point.
give you a minute.
The word in this policy that is doing all the work for Lloyd's interpretation here is the word practicable. And of course, it's already surfaced in the argument. Practicable doesn't mean as quickly as physically possible. And what it means is, or if you look at a dictionary definition of it, it means, I'll give you Blackstone's, any idea or project which can be brought to fruition or reality without any unreasonable demands. Another dictionary definition, able to be done or put into practice successfully. What's the purpose of notice? It is to avoid prejudice to the insurance company. In this context, notice under a policy. There is no demonstration of prejudice here, no proof. The Westinghouse case tells us that the purpose of a loss notification clause is to avoid fraud. There's no suggestion of fraud here. This is just something pulled from the small print, a trap for the unwary that forfeits coverage that was otherwise here. It's a good claim, and I respectfully submit that the court ought let it be considered on its merits.
Thank you.
Good afternoon, Your Honors. Matthew Krause for defendants' respondents. It appears to me that the court is familiar and have read.
So why put a 60-day ceiling defining practicable, right? Otherwise, why have practicable and then have the 60-day notice
I
required?
think the intent of the clause is that any notice beyond 60 days is per se not practicable.
That's not what it says, right?
Well, you asked me intent. I mean, there's
Right.
a lot of ways that this could have been drafted, but the clear meaning of it, because there's an and there, it's notice as soon as practicable and in no event.
So why isn't 51 days practicable given, I mean, you heard counsel, the laws did not even, the insurance provision with respect to loss of business did not start until after 10 days after the
Understood,
incident, right?
Understood, Your Honor. Just going back 1 second, there is no concession or evidence that the 51-day period is the actual period. We believe that it's 62 days. I think the Supreme Court, in their decision, said there's no dispute about that 51, and even based on that 51,
Right.
appellants.
Right, I mean, the email was not produced, right? So, but isn't that why, we should not grant the extraordinary remedy of summary judgment and let some discovery take place?
Well, I mean, it's the appellant's burden to establish compliance with the condition precedent. They had the email, they sent it allegedly, and now they're trying to base notice based on an email that they can't produce, and the response to that email, you can't even tell what that email was in the first place. But in any event, getting back to the clause, here they had July 25th, they had notice, the whole plant was shut down. It's not that one machine or part of the plant was shut down. They had to cease operations. Furthermore,
Why do they have to wait a month until a technician can come to? And they know on July 25th that they have a month's wait?
correct.
Before the technician's going to come to check it out?
That's correct, Your Honor.
Is that an accurate presentation of what occurred here?
Not only that, but when GE finally came to the plant to fix it, GE said, oh, we have to take this whole thing back to Indiana. We can't really fix it here if you want a warranty. So it goes back to Indiana, GE fixes it, brings it all the way back to the plant in Florida. Then they realize when they install it, they got to go back to Indiana because there's still something wrong with the vacuum blower.
It was still vibrating.
It was still vibrating. Only after the second time it was reinstalled, the plant gets back up to operations. They provide underwriters with notice. By that time, we can't even evaluate what the cause of the entire loss.
There were no communications at all?
No, Your Honor.
During that time?
Zero.
I mean, the plant is shut down, right? So practicable, I take it, they're worrying about opening up the place and fixing the blower, right?
But there was nothing for them to do for a month and 2 days before
So there's
GE
no
came.
question, is what you're saying, that come July 25th, there's no question they know they're going to be out of business for a while, and if they think they're entitled to insurance coverage, it's time to tell your carrier.
Absolutely.
Okay.
Thank you.
Thank you, counsel.
Two quick points.
Well, counsel, does the record reflect when exactly the plant shut down? Did it shut down on July 25th?
There had actually been a planned shutdown before that, and in the course
Oh,
of
okay, so
bringing
when was the plant shut down?
it,
The
maybe,
first one?
maybe a week or so before July 25th, they started bringing it back up, I think on the 23rd, and then this event occurred on the 25th.
So the outside date again, I mean, when the plant shuts down, would that not constitute practicable?
No, that was a planned shutdown. I mean, that was for maintenance. They were installing.
But you're not able to do business. You're not able to conduct business.
True, but it was because we planned to take the plant down to install something on the front end of this system. It had nothing to do with the blower.
And Bishop can't fix it at that point, right? He needs GE to come down.
By the 25th, yes.
By July 25th, and then they need to wait more than a month.
But here, and I refer to your prior questions, we're delving into issues of fact. All these points are contested. First of all, Mr. Bishop was trying to get the plant back up with remote instruction from GE. There were a number of other things going on, and only.
But you need to be forthcoming with that information. Sorry. You need to be forthcoming with that information in order to show that your notice was practicable, right? I mean, you talked about an email that you said was sent on or about September 14, but then
Correct.
the email is not produced. I mean,
Yeah, neither side seems to have it, but we do have the response that came on the 16th, and it acknowledged the content of the September 14 email.
Okay.
My last point is to do with the vigilant case again. That case makes the point that wording that forfeits coverage or takes it away, so-called limiting language is what we have in the vigilant case, and what we have here in this loss notification clause. This wording is construed against the insurer where there is any ambiguity, and I submit that if practicability is viewed in terms of its practical intention, which is to avoid prejudice or fraud, the 51 days was perfectly sufficient.
Okay.
Thank you for your consideration.
Thank you both. People versus Andres Rojas Soto. This mask is.
May it please the court, my name is Joseph D. Felice. I'd like to spend at least a little time in the beginning on the invalidity of this waiver of appeal, as the people spent a lot of time in their brief on it. I think the appropriate case is this Johnston case, which the people tried to differ. You know, in the Third Department case in Huckleberry, it's cited in my brief, they cite the Johnston case for the proposition that prior to imposing an enhanced sentence, that the court should ascertain whether the defendant remained willing to waive his right to appeal.
I thought that the promise was a very specific sentence until he absconded, right?
Well, the judge did not specify a number. She specified it would be higher. She didn't say if you abscond or if you violate one of the three conditions, it's going to be 10 years or 20 years. She could have said, you know, it's going to be, it's a B felony, it could be up to 25 years. She never said anything like that. And
So where does it, what case stands for the proposition that a judge at the time of sentencing would have to say a number or give a number if the person does not abide by the conditions?
well, I think that's, it's all implied in this Johnston case, that the defendant has to, it has to be a knowing, willing, and voluntary situation for the defendant.
Well, the
Plus-
defendant, I mean, he's aware of what he pled guilty to what, assault in the first degree?
Yes, Your
He
Honor.
pled guilty to assault in the first degree, so he knows the sentencing parameters for assault in the first degree. But even taking that aside, I don't see anything in that case which says that the court has to say that if you don't return, you will be sentenced to 9 years or 10 years or 15 years.
Well, also, Judge, the August 20, is it the August 25th minutes? Nobody knows where those minutes are. I don't even, and I even asked trial counsel, and he said he doesn't remember what happened, if they walked into court and he just signed the paper, the waiver of appeal, or if the judge was in the courtroom at that time. I know we had to come back at a certain date and sign the waiver.
So I'm
which he
sorry,
did.
counsel, exactly what is the basis for your appeal? That there was no valid waiver because we don't have a copy of the waiver? Or that after the defendant was promised 5 years incarceration with 5 years post-release supervision, he absconded for 1 year, was only brought back because of the rearrest and an alias which he had been using, that at the time that he was brought back, the judge should not have sentenced him to 9 years incarceration?
Well, not because we don't have the waiver, because we have a signed waiver. We don't have the colloquy that would have happened with the waiver when he signed it. The
initial waiver, where he was sentenced to the plea for 5 and 5.
Then, right, the initial one. And I would like to spend some time on the sentence, Judge. I know this court has some discretion in the sentencing. This defendant had no prior record. He explained that one of the reasons he was afraid to come back to court was because of this COVID virus that was spreading at the time. And he had 2 children. He was afraid to go to Rikers Island.
So that's why he was rearrested?
Excuse me?
I thought that the basis for his return to court was because he was rearrested.
That's right. But what I'm saying is the
So
reason
he wasn't
said
afraid of COVID when he was rearrested? I'm not understanding. COVID was not over. As far as I know, it's kind of still going on. So I'm not understanding.
All right, I'm sorry, Judge, but maybe I'll make it a little clearer. He did not come back the first time because of his fear about COVID. And I know that I saw, and I practice mainly in Queens, Judge, but I saw defendants not being sentenced or put to jail. The judges were adjourning cases because of COVID. They didn't want to send him to Rikers. He had a fear.
Well, maybe if he had appeared, he would have gotten a further adjournment.
You're right, Judge. You're right. I can't make excuses
It
for
doesn't
him.
really
But
explain
as
his
far
non-appearance.
as the rearrest, yeah, he was driving his wife's car. His wife couldn't drive because she had some cramps in her
Counsel,
stomach.
this was an unregistered car with Texas plates.
Well,
Where
I
he was
don't think the
rearrested
Texas
after
plates
he
were illegal.
absconded for over a year.
He only pled guilty to disorderly conduct, Judge.
I'm just saying that he was rearrested under alias after a year that he absconded under an alias in an unregistered car with Texas license plates. That's it.
Yeah, but the judge sentenced him almost double the time, from 5 years.
So are
to
you,
life and
so you're saying 9 years is inconsistent?
I'm just looking for, I'm just looking for a little bit of a break on this, maybe 1 year off, or if 2 years off of the
The
sentence.
people were looking for 15 years because it was really a pretty horrendous crime.
Yeah, I mean, the victim lost his eye. And as a result of this incident, the victim lost an eye, had to have a prosthetic eye. So, I mean, it was pretty,
I'm not saying it's not
injury-
serious. You know, Judge, when I put my U.S. citizen hat on, I say, wow, this is a really bad injury.
I don't know what citizenship has to do with anything.
No,
But, you know,
I'm just giving an example.
Yeah.
Yeah, whatever.
I
But,
get
you know,
you.
the point is, I thought that 5 was probably a gift, given the fact that you have a loss of an eye, you know, with such a vicious attack.
The point is that the judge did know about the injury at the time that she gave him 5 years.
Yeah. Thank you, Mr. Feliz.
Thank you.
Good afternoon. Good afternoon, Your Honors, and may it please the court. Stacey Nadell for the people.
I thought we had the colloquy from the plea.
We have the plea colloquy, Your Honor. The minutes that are missing that my adversary was requesting were the August minutes when defendant returned to court to sign his written waiver of appeal.
I see.
But we have the written waiver of appeal, and
So we have the written waiver, we have the colloquy from the plea, but what we don't have is the colloquy when he actually signed the waiver in terms of you've read it over, you've spoken to your attorney, that type of.
that's correct, Your Honor, but all of that, the conditions of his plea, the terms of his plea were discussed in the plea minutes with his counsel present, and counsel it was a virtual proceeding, but counsel and the defendant were both present, and the judge asked multiple times.
Wasn't the waiver of appeal discussed at that time too?
I'm sorry, Your Honor?
Wasn't the waiver of appeal discussed at that time too?
Yes, that's correct, and
He only had to come back because it was being done virtually, so obviously there was a need for him to come in order to sign.
yes, that's correct, Your Honor.
Are there any cases, or even the Johnson case, which your adversary made reference to, People v. Johnson, is there anything in that case or any other case that states that where a defendant remains out pending sentence, that the judge has to inform the defendant that he or she faces X amount of time if they don't return or if they don't abide by the conditions of the plea?
Yes, Your Honor, there are, and I would just like to note that the Johnson case is very different from the circumstances we have here. In Johnson, the court decided that it no longer wanted to sentence the defendant there as a youthful offender and made the decision on its own without the defendant's actions. Here, however, the defendant violated the terms of his plea agreement not once but twice. There were 3 conditions to his plea and to defendant receiving the minimum sentence on his guilty plea to assault in the first degree. Those conditions required him to meet with probation, to return to all of his court dates, and to not get rearrested. And as we know, the defendant was rearrested, and he absconded for over a year from his original date of sentencing. So he violated those conditions twice. And this court has actually held that if a defendant violates the terms of his plea agreement, the sentencing court is able to sentence him to an enhanced sentence.
But we're talking about almost double enhancement, right? The initial promise was 5 years plus 5 years post-release supervision. So he absconds for a year, and now he's sentenced to 9 years, almost double what the original promise was. Is that excessive?
Your Honor, it's not excessive when you take into account the fact that defendant twice violated the terms of his plea agreement. He got rearrested, he gave a fake name, and simply the egregiousness of the crime alone is enough to warrant a sentence above the minimum. I mean, the people were asking for 15 years initially, 16 years after the violations of the plea agreement. I mean, the victim here was just doing his job, and the
15 years is over the top, isn't it? I mean, this is someone with no criminal history. I understand the nature of the crime is terrible, what he did, but, 9 years is double the 5 that the court was willing to give.
It is almost double, Your Honor. However, when you take into account that the victim completely lost his eye, he was lacerated from his hairline into his eye, the globe of his eye was ruptured, he underwent multiple surgeries, he eventually had to have the entire eye removed, he can no longer work in security or martial arts, which created extreme financial stressors on his life in order to keep up with his medical bills and his glass prosthetic. And all of this was known to the sentencing court at the time of sentence, and the sentencing court fashioned the appropriate sentence while considering all of these. And if there are no further questions, we ask that you affirm and uphold the defendant's sentence.
I think we're good. Thank you.
Thank you, Your Honors.
I'll rest on what I said. I just want to draw the court's attention to page 6 of my brief, where I do cite some cases from the First Department with very serious crimes where this court has reduced sentences. So, I'd ask that your court consider a reduction, even if it's a very slight reduction in the sentence. Thank you very
Thank
much,
you.
and have a good day, Judge.
You got it. Thank you. You too, Mr. Feliz. Cano versus AMA.
Good afternoon, Your Honors. May it please the Court. Brian Isaac, I represent the plaintiff appellant. I'd like to split my argument in two, if I can, 240 sub 1 issue and the 241-6 issue. I'll deal with the 240 sub 1 issue first.
Well, 240 should be quick, right? We're talking about a 11-pound piece of cardboard.
Well, the cardboard has varying amounts. The defendant's expert said it was 45. The plaintiff said it could be 60 to 80. One person said it was 25, but it's clearly a piece of sheetrock. And I'm, quite frankly, relying, Judge Acosta, on the decision in Rodriguez against DRLD Development Corp., a case that I think is indistinguishable from this, with the exception of the fact that I'm asking you for summary judgment, and I'll tell you why. In Rodriguez, and I'm reading from the decision, this is at page 409, plaintiff, quote, tripped on a metal cable, dislodging a pile of sheetrock boards, which stood approximately 8 feet high and were leaning against a wall not in use. Plaintiff attempted to stop the boards from falling with her hands and head, but she could not support their weight and suffered injuries. In this case, the plaintiff wasn't injured trying to arrest the fall. The plaintiff was obviously injured when the board came and struck him in the head, causing injuries. Now, it is true that in the Rodriguez case, you did, citing to the Walensky case, say that summary judgment couldn't be granted for the plaintiff because there was a question of fact respecting whether or not there was a device that should have been put in place to stop that.
But that was factually distinguishable too, Mr. Isaac. Wasn't Rodriguez involving a pile of sheetrock boards resting atop wooden blocks?
Yes.
On the same floor that the plaintiff fell?
Yes, but here you're dealing with, with respect to summary judgment, my opposition to summary judgment, we have a device that weighs anywhere from, say, 25 to 80 pounds. Defendant says it's 45. It's unsecured, not tethered to anything, and represents an obvious potential hazard. Now, as you know from the Ortega decision, the foreseeability that's required in a 240 case isn't the same as a negligence case. If you could see that there's a potential hazard, that's fine.
Well, sir, you keep using the word hazard, which needs to be in there somewhere, but 240 doesn't cover the average and ordinary construction site hazard. We need to have the elevation-related hazard. We have to view that through the prism of runner. So with that in mind, how did this single plywood sheet constitute an elevation-related hazard?
Well, Judge Higgett, what I would say is that the Walensky decision, in which the Court of Appeals said that we were all reading the Miserati decision incorrectly, including me, said that even if something is on the same level, in terms of the base of it is on the same level as the plaintiff, where there's an elevation-related risk, that doesn't preclude application of 240.
But Walensky talks about falling objects, right?
This is a falling object, though. The base of the sheetrock is at the foot of the plaintiff, but it's above the plaintiff's head, and it's falling on him. And I think that when we look at the labor law, we're supposed to construe it in a manner that's broad. That's what the Runner decision said. We also have the more recent case, Rincon, which I know you've read, which is the tethering device case, where the defendant made a very similar argument. I know the case. I was on it. The defendant there said that a wrench wasn't something that should have been secured because it was Judge Higgett, as you said, a normal hazard. Yet this court reversed the denial of summary judgment, granted plaintiff summary judgment, and specifically found that a tethering device of some time was appropriate. So here, I know the experts spoke about different devices, and I know the trial court was critical of plaintiffs' reference to a device that was used to actually keep sheetrock in place, but I don't think you need to go to any external device. If you look at the statute, it covers stays, slings, braces, irons, ropes, or other devices. So in this case, all you have to do is take this device and just tether it in some way so it didn't fall. I'd also point out with respect to the difference between this and the Rodriguez case, that my review of the record shows that Mr. McGinnis of Andrew James testified that the procedure at this site was not to keep these devices upright so they could fall, but rather to put them flat on the ground. And I would refer you to the following pages of the record: 1347, 1373, and 1418. So here you have that additional fact, as you were saying, Judge Higgett, that wasn't present in the Rodriguez case. You have testimony from the actual carpentry subcontractor that this wasn't supposed to stand up there. Okay. And my other point, I won't go over because I know I have 2 minutes. The reason that I think the defendant's analytics are off is because I don't think you can have different protections in the labor law with respect to different people. And the example I give, I always give sports examples because I understand sports. If Muggsy Bogues, who's 5'3", is doing a Habitat with Humanities project with Manute Bol, who's 7'9", and they both get hit by an object that's 8 feet, it wouldn't make sense for any court, in my view at least, to say Muggsy Bogues gets the protection of the label because he's smaller, and Manute Bol doesn't because he's so tall. It should be one standard for everyone. Thanks.
Thank you.
May it please the court, Henry Masha for respondent Jamestown. The Supreme Court order should be affirmed. And I'll start with the 240 claim since that's where we left off. The fact of the matter, whether there was negligence or not, this was not an elevation-related hazard. The piece of sheetrock was on the floor and it tipped over.
Why is this different than Rodriguez?
Because in Rodriguez, the piece of sheetrock was on 2-foot-high blocks. That's a big difference. And I'd point out that the...
But you admit the sheetrock was 40 pounds, right?
It was between 35 and 40 pounds, but we know that the full weight didn't fall directly on the plaintiff because it was because it was on the floor and tipped over. And I would just point out that the second department in Perino addressed a similar issue with sheetrock falling over.
How do we know that the full weight didn't fall on the plaintiff? I mean, it's leaning, the testimony was by the plaintiff and also someone was walking behind the plaintiff at the time. It was that it was leaning against the wall. As the plaintiff walked by, it fell onto the plaintiff, causing the plaintiff to go to his knees, right?
Right.
So why are you saying that the full weight?
Well, because it's leaning and it tipped over. So part of the sheetrock is obviously resting on the floor. It didn't come up off the floor. It's not a falling object that came down from the ceiling.
Well, there is a height differential, yes?
There's a height differential, but it's de minimis. And the second department...
It's de minimis, unless the 40 pounds fall on you.
Didn't AMA...
The question isn't whether it hurts. I mean, that's not...
Well, he fell to his knees, right?
He did. I mean, that's true, but
Didn't Whitty, AMA's experts, say that the sheetrock weighed only 11 pounds?
He did. That's right. And I think it's that's accurate.
35 to 40, so how...
Well, I think the expert said that was the weight that, the amount of force that came down. That wasn't our expert, but that was another expert.
Well, that's the key, right? After Runner, it's not so much whether the object is even at the same level as the plaintiff or whether it's de minimis. It's, was there a danger emanating from the force of the gravity? And so here, I understand you, that's part of the equation, the height differential, if any, be it de minimis or be the part of the object was at ground level. But it seems like a lot more goes into the soup now in determining whether there's an elevation-related hazard than simply the de minimis nature of the height differential.
That's right. There is a lot that goes into it. And I would just direct the court to the Perino case in the second department, where they found that sheetrock tipping over was not an elevation-related hazard. And I would encourage the court not to create a department split and affirm the dismissal of the 241 claim. With regard to plaintiff's cross motion for summary judgment, that was clearly untimely. All the parties knew that summary judgment was due on June 9th, and all the defendants, in fact, filed their summary judgment motions by that date, except for the plaintiff, who took that opportunity to review all the summary judgment motions, even abandoned their 241-6 claims with respect to the sections of the industrial code that were originally in the bill of particulars, and then Cross moved to add new provisions after discovery was closed and after they got to review all of our summary judgment motions.
So that was after the stipulation?
After the stipulation, right. And the March stipulation said that that summary judgment motions were due June 9th, and the May stipulation didn't replace that. It was really an extension. It just said a common return date and a briefing schedule. It wasn't designed to give a new deadline, and we know that because all the defendants moved by June 9th, except for the plaintiff. And so that was unfair prejudice to us because the plaintiff gained an unfair advantage there. And I will just move on with my last minute to the 241-6 claim. You know, the industrial code that plaintiff sought to add doesn't even apply here because it's undisputed that it was a single sheet of plywood, so it wasn't a pile, and that this was an open workspace. Plaintiff himself testified that it's an open workspace and that it wasn't really considered a corridor. And with regard to the building materials.
But you agree that there's no evidence that the sheetrock was being used at the time of the accident, right?
No, I wouldn't agree with that. I mean, the plaintiff himself said that the carpenters were using the sheetrock that fell. That's on page 280 of the record. And then plaintiff also testified that the carpenters were, quote, still using sheetrock in that area on the date of the accident. That's on 308. And it was just cut in half.
I thought AJI had said that they had completed the work, the sheetrock work, or the work that was needed, the work that required the sheetrock had been completed, I thought, in like January or something.
They had suggested that some of the timing was a little bit fuzzy from the record, but plaintiff himself, who was there, said that it was an open workspace and the sheetrock was not done yet.
Is it foggy enough to not decide the issue as a matter of law?
No, I think plaintiff's testimony is enough to grant the defendant's summary judgment.
I thought you would say that. Okay, thank you, counsel.
Good afternoon, Your Honors. May it please the Court, my name is Karen Wagner of Kaufman, Dolowitz, and Volokh, and I represent the respondent, AMA Development Infrastructure. The lower court's decision should be affirmed in all respects, Your Honors, because this case is on all fours with this court's decision in Macarius, which the lower court quoted extensively. In Macarius, we had a plaintiff, coincidentally enough, the same height, 5 feet 8 inches, who was struck by a transformer that was approximately 6 or 7 feet high, meaning there was a 2-foot differential. He too was standing on the ground. This plaintiff was not subjected to an elevated relation risk. As he himself admitted, he was walking on a level floor in an established building. And because of the similarity to Macarius, this court should affirm. As to what the court brought up, or this court brought up earlier regarding the de minimis height, a particularly strong aspect of the lower court's decision warranting affirmance was that it took into account appellant's argument about the weight exception. And it analyzed that, and the lower court even noted that the cases that appellant cited on the summary judgment motion in favor of the weight exception actually went against them because those cases spoke to an object that was at least 3 times as heavy, the lightest one being something like 300 pounds. So the record before you, Your Honors, shows that the lower court carefully considered every aspect of the case, which, as I said, was on all fours with Macarius of this court, and also the lower court engaged in the weight exception, warranting affirmance by this court.
Does the variation in the respective witnesses' accounts as to the weight of the sheetrock that struck the plaintiff, does that raise a triable issue of fact?
No, Your Honor, I don't believe it does because, as noted, the cases on the weight exception speak to something being at least 3 times as heavy as what we have here. The range of weight that was cited in the record is anywhere from 40 pounds to 80 pounds, and I think somebody might have gotten even closer to 100. So based upon that, we're nowhere near the threshold, the lightest one being something like 300 pounds, as I mentioned in the cases actually cited by plaintiffs in their summary judgment motion. So I don't believe...
Is there any question that what we're speaking about here is a half a piece of sheetrock?
Well, you mean making it lighter? Is that the
No,
court's
no,
question?
the item that fell it wasn't a full piece of sheetrock, right?
Correct. There was some alteration being done to it, but I don't, I
And it was
think that-
one piece.
Correct. That is correct. And I also note that there was absolutely, plaintiff himself admitted that there was absolutely no issue with the securing of single panels of sheetrock in the entire time that he was on the job.
Assuming it was being used, right?
That is correct, Your Honor.
Thank you, counsel.
Thank you, Your Honors.
Okay, Andrew James.
Good afternoon, Patrick Lawless for Respondent MLB. I'd just like to be very brief. I'm not going to take much more of your time. I agree with all the arguments that have already been made by my co-respondents. I'd just like to point out, as Justice Higgett said, this is an accident that involved the ordinary dangers of a work site and not the extraordinary risk of an elevation-related risk. With respect to the 241-6 claims, it's clear that the provisions that, first of all, the provisions aren't even contained in the plaintiff's BP. The court appropriately exercised its discretion in denying the plaintiff's motion to amend the BP, but in any event, they're completely inapplicable. This happened in an open work area, not in a passageway, and it didn't involve a tripping hazard, and for that reason, the court properly dismissed the 241-6 claim. If there are no further questions, I'll just rest on my brief.
I think we're good. Thank you. Okay. I'll give you the minute, 30 seconds.
Should I wait till it goes off?
No, you're good.
All right. Good afternoon, Your Honors.
120 now.
May it please the court. Adrian, you're on. Cullinan Dykeman for defendant Andrew James, referred to in the papers as AJI. The lower court dismissed plaintiffs' labor law 240 and 241 claims against AJI because AJI established prima facie it is not an entity subject to liability under these statutes. This portion of AJI's motion was not opposed by plaintiff in the court below and not preserved on appeal. Moreover, plaintiff didn't make any argument whatsoever as to that topic on appeal. So the motion court's decision dismissing 240 and 241 as to AJI should be affirmed. With respect to the labor law 200 and negligence claims against AJI, these also were dismissed by the motion court based on AJI's prima facie showing that it did not create the hazard and was otherwise not negligent. That portion of AJI's motion was also not opposed by plaintiff before the lower court and is not preserved on appeal, should not be considered by this court. Zimmerman v. Gaines, 249 AD 2D 215. To the extent that, plaintiff also made no argument as to the labor law 200 or negligence claims in its main brief on appeal. To the extent that plaintiff belatedly, the first time anywhere in this case, made some argument as to the negligence and 200 claims against AJI in his reply brief.
But the appeal is framed in terms of 240 and 241.
Exactly.
They don't mention you. Take yes for an answer and take the red light.
And in any case, the arguments are made for the first time in the reply brief on appeal, which should not be considered by this court.
Thank you, counsel.
Thank you, Your Honors.
Good afternoon. May it please the court, Elizabeth Streelman for TF Nugent. I will, generally speaking, just rely on my learned friends back there who I think did a great job in terms of these arguments. However, I did just want to point out that this is a case, and I think the lower court got it right, where there was no expectation or necessity for a securing device. The securing device, which was proposed by the plaintiff's expert at the close, or really after discovery at the time of the motion, is something that the court correctly pointed out.
Was that a rock-steady clip?
Correct.
But that's what the expert Silverberg had suggested. But isn't that something that would only be used if you had more than one piece of sheetrock? It's
Correct.
not something appropriate for a single piece.
Correct, Your Honor, and it also speaks to the fact that you need to have studs or beams or something for it to connect to. So I do believe the lower court got that right. I would also just point out the Seals case from the Second Department, SEALES versus Trident, cited in my papers, which also pertains to a falling piece of sheetrock where they found that it was not something that was being hoisted or secured and not something where a device was actually required.
Thank you.
Thank you very much.
I'm sorry, Judge Higgett, apropos to your questions, I just took a quick look at the record, and I just want to give you the differentials with respect to the estimates. The plaintiff's estimate was 10 to 12 feet, it's 282, 60 to 80 pounds, 353. McGinnis of James at 1327 and 1355 estimated it at 25 to 30 pounds. Plaintiff's expert estimated it at 72 to 80 pounds, 3852 of the record, and defendant's expert, and Judge Friedman, you were asking this question, said it was 45 pounds at 2615 of the record. So if you take those scenarios, assuming you don't grant me summary judgment, I don't think that there should be a distinction here. I don't think summary judgment should be granted because I'm entitled to the most favorable evidence I can opposing the motion. But Judge Acosta, with respect to your assertion, some of my adversaries' assertion, that you have, in the Rodriguez case, 8 feet plus 2, we still have 10 to 12 here potentially. Now, I thought that the plaintiff said that the full sheetrock fell on him. Clearly, his co-worker said it was cut in half, it was an 8x2. But my point, I guess, on the 240 is this. If you look at the practical realities of the workplace, you're trying to avoid these accidents. If a pile of sheetrock falls and a single sheetrock falls, they're two different things. But if one piece of the pile falls and strikes the plaintiff, you're dealing with the same risk. I know the labor law is intensely fact-intensive. I know that's very hard to reconcile the decisions. But my adversaries keep relying on Second Department precedent, which is not nearly
as... counsel alluded to objects, you know, that with a gravitational force that's significantly higher than one sheetrock that weighs 40 pounds, right? I think counsel talked about some of the cases from this department that talked about 300 pounds.
Right, and please, I'm not going to tell you that there isn't a difference between 300 pounds and 500 pounds or 2,000 pounds and 40 pounds. Here's what I would say, though. If you're a construction worker working on a construction project and something hits you that's 45 pounds, 70 pounds, 100 pounds, that's pretty heavy.
Well, counsel, I just want to go back to this weight issue.
Sure.
Because I was under the impression that when we're talking about the 72 to 80 pounds, that plaintiff was providing testimony regarding the weight of a full sheet. But we don't have a full sheet here. It was just a piece. He said he never saw the piece, and certainly even the expert, did he make any effort to weigh the piece? So we don't know what it weighed.
Take my worst case scenario. Let's take what the defendant did, 45 pounds. 45-pound fall when you're at a construction site is not insignificant, if I can use a double negative. And the fact of the matter is that it's not secured in a situation where the carpentry subcontractor said not once, not twice, but 3 separate times that the proper procedure was to place it on the floor. Yes, those are all distinctions, but assuming you don't agree with my...
What weight did Whitty put on the sheetrock?
He said it was 11 pounds, but he wasn't sure of what it was either. And the fact of the matter is that we're not talking about forces because, if I could, Judge Friedman, that was the exact same argument that defendants made in Rincon. which was my case. They said that a 1.5 to 3 pound wrench was a device that didn't have to be tethered because it was an implement and was so small. And this court said no. You needed tethering device for it. It used the term tethering device. So in a worst-case scenario for me, I don't think summary dismissal of the case is appropriate, and I would ask you to grant summary judgment to us on the 240 claim.
Thank you, Mr. Isaac. Thank you, everyone. James Johnke versus Foot Locker. You may.
I'm sorry. Feels good. Good afternoon, Your Honors. Bernadette Panzella for James Johnke, the plaintiff appellant in this action. The first thing that I would like to do is to call the attention of this court. I have 4 points that I would like to highlight for Your Honors. Last time we were here actually was Judge Friedman who said, what you're really looking for here is to amend the complaint. And this is exactly what was remanded back to the Supreme Court. However, the Supreme Court here went beyond that remitter, and it's respectfully submitted that going back, I think, to the 1800s from the Court of Appeal, the motion court cannot do that on remit from the appellate court. Second point is that, and I will refer the court here to the fact that what distinguishes this case is the fact that there was a default judgment granted in June of 2000. And upon the granting of the default under Rokina, which I've cited in my brief, the default...
But that sort of begs the underlying question, right? The underlying question is, what is the evidence in the record that Foot Locker acquired the assets or merged with Foot Locker Inc., right? Are they, in order to create succession liability, right?
Well, Your Honor, if I may, most respectfully, it's our position on the plaintiff's side, well, actually, I guess it's my position, that I have an admission by an attorney from the year 2000 upon which the default was granted. That was from Regine DeLay-Rizard, from the Foot Locker affiliates, contract attorneys, defense attorneys, making the admission that the defendants were the successor in interest. Now, what happened from that point is that after a lot of delays with Reliance's insurance, you know, that went on for many years, we come up to the time when there was a court date for an inquest on damages following that default. That notice of inquest was sent to Barry, McTiernan, and Moore, the same attorneys who made those representations in opposing the motion for default. They didn't show up for the inquest proceeded, then I hired a collection attorney, and we went forward from that point. So our position is that that admission was made so long ago, nobody did anything to vacate that default. As a matter of fact, although it was stated differently by defense counsel or defendant appellants, Judge Goodman said the only reason why the default wasn't going to be granted to Foot Locker when they came in 2009 is because they first asked for that relief in a reply on their motion to quash the information subpoena and the subpoena to obtain money from Foot Locker. And I would refer the court to, at page 376 of the record, is the April 20th letter April 20th, 2009 letter giving Barry McTiernan notice of that. I would also...
So there's no evidence other than the judicial admission, right?
Yes, and the judicial admission, even if you take the best case scenario from the defendants, which is that it's an informal judicial admission, the remedy for that is to give an excuse or offer an explanation at the time of trial. There's been no hearing here. There's been no trial here. James Jonke has never had his day in court. Never. Nothing. So what happens here now is now they're coming in. They did nothing to vacate the default. They did nothing to correct the mistakes. So the first defense that the defendants come into here say that, this law firm wasn't hired by us. They didn't represent us. They had no authority to do that. However, we have the letter from Donna Falzone from Venator Group that instructs Barry McTiernan to go in and answer this motion on default to protect the interest.
So that's what I don't understand. There's nothing else in the record that suggests that Foot Locker Inc. or whatever is the successor in interest. Nothing else other than this informal or formal judicial admission. So why is it that we should rely solely upon that informal judicial admission or formal judicial admission in order to find that it is a successor in interest?
Well, Your Honor, because this goes back to the year 2000, and they have done nothing to correct that in all this time. They've done nothing to redo it, and even the court...
Well, sure they did, because on the motion, they put in papers and evidence to show that that was an error, that it actually was not a successor in interest.
Well, actually, Your Honor, most respectfully, I don't believe that they did that. All they did was they said that the lawyer had no authority to make those representations, although in the verification, she said very specifically that she made them based on admissions made to her by the defendants. The second thing that they did is that they didn't do anything to, the next defense they took is that it was a mistake. Well, we have no affidavit from the attorney who made the admission saying it was a mistake.
Is there any reason to doubt that the Aramar Drive address at which...
I'm sorry, Your Honor, I didn't hear you.
That the Aramar, A-U-R-A-M-A-R Drive address at which service has been made at some points in the course of this action is not Foot Locker that you are seeking to pursue?
I agree with that, Your Honor. However, letters with the affidavits of service were sent to Village Wheels Bike Shop on 8th Street, which is part of the named defendants. Also, Your Honor, I would bring up, the next point that I would like to bring up is the fact that Foot Locker has had notice of everything that's been going on here because their affiliates were named in this lawsuit. The affiliates were named. Now, they have, in the beginning, way back with Judge Goodman, she said, let's look at the insurance files. Well, somehow Foot Locker got the insurance files of all their affiliates without a subpoena, without notice to the plaintiff, nothing. And then they put in a big privilege log saying that, oh, the affiliates who were never named object to a lot of this information going over to the plaintiff or being revealed to the plaintiff. We had no discovery in the underlying case with Foot Locker. One person came in, Peter Clay from Wilbur's, and said, we don't know anything. No records, we have nothing.
Counsel, if I may, how do you with Justice Engoron that they were not arguing that Foot Locker was a successor in interest to the Foot Locker, Inc.?
That was me, and I'm going to read the full quote, if I may, which is in my brief. I'm sorry.
Yeah, because I was under the impression that Justice Engoron posed that question as to whether or not they were pursuing successor liability, and counsel indicated that that was not the argument.
Okay, no, the argument is, excuse me, if I just may, let me get the right page.
Would that be 688?
And I put it in here. I'm so sorry. I'm so sorry.
That's okay. Why don't you read it in rebuttal?
Okay, thank you, I will find it. But I would also like to just point out that the judge, and I have a great respect for Judge Engoron, but the judge went beyond what this court sent to the judge.
Counsel, I'll let you do that in rebuttal because your time ran out a while ago.
Okay, sorry, I will find that. I will find that quote.
Good afternoon. David Zellman with Kelly Dry & Warren for the respondent non-party Foot Locker, Inc. And I will start with a quote that's on page 688 of the record. The court directed the following question to plaintiff's counsel. Are you arguing that the current movement that David's client was some sort of successor in interest to this upstate defunct corporation? Is that your argument? And Ms. Penzella answered, no, 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 not at all. So the Supreme Court correctly denied plaintiffs' post-judgment motion to amend the caption to substitute respondent as a defendant in place for this completely unrelated default judgment debtor for at least two reasons. First, the evidence conclusively establishes that respondent is not the successor in interest to the default judgment debtor, which plaintiff's counsel openly admitted to the Supreme Court. And second, respondent's actual affiliates, respondent's subsidiaries, were all previously dismissed from this case on the merits more than 17 years ago. So there's no basis to impose liability against respondent.
That was my question. I thought this was a motion to amend the caption, right? And that was the denial.
Correct. It is a post-judgment motion to amend the caption. And this case has a long and somewhat convoluted history, and I think it's important to explain how we got here.
It's okay. I've read the brief, I don't know how many times, and I'm tired of Foot Locker and Boot Locker and everyone and all the other lockers. I can't anymore with the lockers.
Could we sum it up in one sentence by saying the Foot Locker got mixed up with Foot Locker?
That's exactly right. That's exactly right. And there's no dispute.
So that's what I'm not understanding now. My colleague asked the question of your adversary as to whether or not there was any evidence or any argument that Foot Locker is a successor in interest, and I thought the answer was no. So therefore, if the answer is no, how do we then amend the caption?
You're absolutely correct, Your Honor. There's no basis to amend the caption. There is no basis whatsoever to amend the caption. My client, Respondent Foot Locker, is a publicly traded global athletic retailer headquartered in New York City, whereas the default judgment debtor, the Foot Locker, which had that name for 2 years, is a defunct limited liability company whose registered place of business is located in a single-family residence in upstate New York. It was dissolved 6 years before the complaint had been filed, and the sole member of the company had died 1 year before the
So is the argument that in all these years and all the years of litigation, which I guess started back in 1999, I think?
Correct.
Is the argument therefore that your client did nothing during this period of time to attempt to redress or address the issues?
My client's subsidiaries were named defendants in the complaint. They owned the store that sold the bicycle. And in 2005, well after the default judgment had been entered, the court granted summary judgment because it was undisputed that the bicycle had left the store in a perfectly good manner. It wasn't defective when it left the store. So yes, Foot Locker's subsidiaries were named defendants, but the default judgment debtor was a completely different defendant that had no relationship whatsoever to Foot Locker. Excuse me, Foot Locker, Inc., my client.
Yeah, thank you.
Thank you. Yeah, I was just going to correct that.
And that's, and that's where the confusion really stems from, right? Is that these two companies really have confusingly similar names. And
Can you address the formal or informal judicial admission?
Yes.
Why an affidavit from prior counsel was not submitted?
So let me address the admission. So Plaintiff relies on a mistaken signature block in a proposed answer that the court never accepted, which doesn't say successor in interest. What it says, it incorrectly described Venator Group. Now, Venator Group is the same company as Foot Locker, Inc., my client. It just changed its name in about...
Well, it says as successor in interest of F.W. Woolworth, here's another one.
No, if you read...
Company, right?
Your Honor,
Venator
keep
Group
reading.
doing business as the Foot Locker, Inc.
No, it is excuse me, let me get it. It says that Venator Group, DBA, the Foot Locker, Inc. It says Woolworth as successor in interest to Venator Group, DBA, the Foot Locker, Inc. So even if that were true, even if Venator Group did business as the Foot Locker, Inc., that doesn't establish that there's a successor relationship. In order to establish a successor relationship, the plaintiff would have to show that respondent both purchased the judgment debtor's assets and either expressly assumed its liabilities or merged with the judgment debtor or was a mere continuation. But
that was the affirmation that was submitted in opposition to the default, right?
That's right, because there was confusion all over the place. And if you look at the Falzone letter, this June 2nd letter, which is the letter that instructed counsel to put in an answer from Venator Group's claim manager, Donna Falzone, instructing the Barry McTiernan firm to file an answer, it states, Boot Locker, Inc. is not an entity of Venator Group. Boot Locker and the Foot Locker are the same company. So what Ms. Falzone was saying was, hey, there's some confusion. Make sure that it's understood that Venator Group doesn't get confused with Boot Locker. These are separate companies.
But in response to this motion, why not simply get an affidavit from that attorney stating that they made a mistake, that they were incorrect in terms of whether it was a successor in interest or not?
Your Honor, as I stand here now in 2023, I can't answer that question going back to 10, 12 years. But it's plain, the undisputed evidence, I think it's plain that these are entirely separate companies. And plaintiff did not rely on that proposed answer. If plaintiff really believed that the Barry McTiernan firm represented the default judgment debtor, she would have served the default judgment debtor on that firm. Rather, plaintiff's counsel, after the court disregarded the proposed answer and the Barry McTiernan firm had submitted and awarded the default judgment plaintiff served notice of the default judgment at the single-family residence in upstate New York where the default judgment debtor had been registered to do business and indicated on that notice that the default judgment debtor was pro se. That's reflected on page 131 of the record. So she was fully aware.
Thank you, counsel. Okay, you got 2 minutes.
Okay, thank you. Thank you, Your Honor. First of all, I wanted to answer what counsel just said last. That was also served on Carol Burns and Russo Tamagillo, which took over for Barry McTiernan and Moore. So that was served on October 6, 2000. Second thing is, this is the corporate purpose, and this is at page 38 of the record, for the Foot Locker, Inc. up in Ormauer. To establish, purchase, lease, or otherwise acquire, own, operate, sell, mortgage, et cetera, et cetera, et cetera, a retail and wholesale sporting goods and wares business and deal in through purchase, sale, lease, and exchange, all sporting goods and materials, et cetera, et cetera. So this was another sporting goods store, and...
But was it the sporting goods store that we were concerned with? And so now, could you answer the question that my colleague asked previously in terms of your response to Judge Engoron's question?
Yes, here it is. It's on page 11 of my reply brief. In their brief, defendant Foot Locker's attorneys include a partial quote by plaintiff's counsel from the argument on the CPLR 2221D motion, but omit the full context. Here it is. Plaintiff's counsel, Ms. Panzella, this is from the record. My position here is that in 2000, the attorney who had both the apparent and actual authority made these representations, certainly to me as counsel for the plaintiff and to the court, that the Foot Locker, you know what this is already, okay? The successor in interest issue. So in that now, 22 years later, they want to say, no, never mind, that was a mistake. They do not have an affidavit from Donna Falzone saying that she made a mistake. We don't have an affidavit from Barry McTiernan and Moore saying that they made a mistake. They have an action in malpractice against Barry McTiernan and Moore, which is their remedy going back over 125 years now, and this is now 2022. The next thing I would like to just point out to the court is that page 221 of the record. This is the actual letter from Barry McTiernan and Moore asking me as plaintiff's counsel with a copy of the letter from Venator Group to please adjourn the motion for default, which I did. I agreed to. So that's 221 through 226 with the stipulations. Another thing, at page 289, deponent, which is Regine DeLay-Lazard from Barry McTiernan Moore, says in her verification, deponent further states that the grounds of my belief is to matter stated on information belief, a drive for admissions of the defendants to the deponent.
Counsel, I have another question, sir.
Yes.
Excuse me. So Venator Group changed its name to Foot Locker in, I believe it was 2001. Am I correct about that?
Well, here's what happened.
Let's do this.
Yes.
Let's assume that Venator Group changed its name to the Foot Locker in 2001, because I believe that's accurate.
Yeah.
So if that's the case, the summons and complaint was served in 1999. So how could it be served on them when, you know?
Well, see, this is why I go back to the affirmation under oath, under penalty of perjury, by the attorney who represented them with both the apparent and the actual authority. They had notice of this from Venator Group. No one sought to collect this. So what does, I guess my question is, so what does the plaintiff do? We have an affirmation from attorney from the year 2000. So we're no longer going to accept attorneys' affirmations anymore? Or we're just going to say, well, if they said something and they never corrected it, because it's only defense counsel who says that it's a mistake. Why don't we have an affidavit from Donna Falzone? Why don't we have an affidavit from Jean Renee-Lazard? And by the way, when I served a subpoena to take the depositions of those, not Donna Falzone, but of Renee Lazard, it was defendants who moved to quash that. We had no discovery by Woolworths in the underlying action before summary judgment, and we have none in this, nothing. They gave a privilege log for their insurance files, which have all these affiliates all over reporting to each other under Venator procedures. So what is the plaintiff to do if an attorney, another attorney says a prior attorney first, they didn't have authority to represent us, which of course is not true, and, and we didn't, well, they made a mistake, but we're not going to give an affidavit. We're going to preclude you from taking the deposition. When do we get our day in court?
Thank you, counsel. Thank you both.
May I say just one thing? One thing, I promise.
We've exceeded the 15 minutes already, okay?
All right. Thank you very much, Your Honor. Thank you very much for your patience, and thank you.
Thank you, counsel.
Good evening. Power J. Chen on behalf of the Law Office of Kim Chon Lim, on behalf of the plaintiff appellants in this matter. That's all of the SSP entities. If it pleases the court, I will begin with plaintiff appellant's appeal concerning the dismissal of the bad faith claim Specifically, the plaintiff asserts that we have pled plenty of facts within our complaint giving rise to the inference of denial and bad faith coverage. Specifically, these facts exist in 3 categories of facts. The first is our request for a tolling agreement. That request was first made on May 12th, about 4 months after the claim was first filed. The request for a tolling agreement was renewed perpetually, but was continuously denied. The second would be the timeline of the denial of coverage, specifically that the First Specialty Insurance denied coverage about 1 week after finding out.
The bad faith claim was dismissed because it was duplicative, right?
That's correct, Judge. Yes, Your Honor.
Is it?
It is not, because we have pled separate facts giving rise to the inference of bad faith. Specifically, we are not saying that it was bad faith because they denied our coverage. We are saying that they engaged in conduct in bad faith to try and essentially make us blow the statute of limitations. We raised this
But you didn't blow the statute of limitations.
No, Judge, we did not. We went ahead, we filed suit.
Because you asked them for a tow, right?
Yes.
And they didn't give you a tow.
Yes.
So you knew that if you wanted to protect your rights, you had to start an action, which you did.
That's correct, Judge.
Where's the bad faith in that?
Well, so in the totality of the circumstances, Judge, Your Honor, with the other 3 categories of facts presented, we would submit that that is evidence of bad faith.
Counsel, I'm actually looking at the complaint, the second cause of action, and I'm comparing the allegations in the second cause of action to the third cause of action, and it's pretty much the same.
Yes, Judge, but the facts that are alleged in the remainder of the complaint upon which those causes of action are based are distinct.
And I'm looking at those 2. I don't see a difference, but maybe you can point me to those paragraphs where there is a difference, because I don't see it.
Yes, Judge. So specifically, I would point the court's attention to paragraph 52 and 53. In paragraph 53, the plaintiffs point out, we actually borrow language from some communications between the parties. It states, this is by way of explanation, Your Honor. This is in response to First Specialty's request for more information concerning how this loss arose. We clarified to them, Farrington Construction retained Carpenter's touch to remove windows and patio doors and replace them at Cedar Creek, Shannon Glen, and Pine Creek. Those are three of the properties at issue. Through information and belief, the removal and replacement of windows and doors was the primary source of the asbestos contamination. The surfacing material on the drywall was friable ACM and was disturbed during the window/door replacement. Additionally, non-friable ACM was also disturbed in the form of window caulking at some properties. This excerpt was provided to the defendant in or about August of 2020, 2 months prior to their request for this information. That's why the beginning of this excerpt states, as previously advised, because this was part of a memorandum that was already provided to the defendants. Additionally, we would also point towards the history of this case, Your Honor. There were 4 insurers that actually were part.
Counsel, back to the duplicative, the issues whether it's a duplicative or not. You're requesting the same damages, are you not, in your breach of contract claim?
The breach of contract and the bad faith denial?
Yeah,
No,
aren't
Judge.
you requesting the same damages for both?
No, Judge. The bad faith denial of coverage would allow,
Well, you're seeking the consequential damages, right?
Yes, exactly, Judge. So that would be the main difference, is it would remove the policy cap for practical purposes.
Thank you, counsel.
Thank you, Judge.
Good afternoon. My name is Todd Tippett. I'm with the Zell Law Firm, and I represent First Specialty Insurance Company, the respondent and cross appellant.
So it's a 30 to 11, is that correct?
Correct.
no discovery has taken place?
That is correct, Your Honor. I'm going to address our appeal, which is the breach of contract piece, where the Supreme Court denied our pre-answer motion on whether or not the pollution exclusion within our policy would eradicate this entire case. What the judge did there is she's relying on 3 cases that are all out of the CGL or third-party property line of cases. This is not a third-party property case. This is a first-party property case. There is a line of cases here in New York that apply a pollution exclusion in the first-party context and found that asbestos or silica falls within the pollution exclusion definition. And we would request that this court take a look at those cases, specifically American Heritage, a 1994 case, as well as the Broom case, a 2015 case, where those courts specifically found that when a contractor went in and...
So let me ask you, if you use the rule of justum generis, since the exclusion speaks, one of the items listed is something resulting from a thermal cause, wouldn't that exclude the argument you're making about asbestos? Because asbestos would not be consistent with a thermal cause?
Well, I would argue that thermal is just one of the many words that define or classify irritant. There's also the word solid at the beginning of that definition, and that would also...
But there's no word asbestos in there.
You're right, Your Honor, and that's a good point. But if I defined or put in there every pollutant that there is in this world, I'd have to get a Mack truck to deliver a paper copy of this policy. We made that pollution exclusion broad to encompass all pollutants.
Well, we can agree that asbestos is an important exception if it's going to apply, and it is one that is invoked from time to time, so it's not an unforeseeable category or type of quote-unquote pollutant. So, you know, spending the 10 letters or so to identify asbestos is not going to be that expensive in space in the policy for a really meaningful policy term.
Your Honor, respectfully, if I put the word asbestos in there, then what people would say is, well, this only applies to asbestos. It doesn't apply to lead, and it doesn't apply to Roundup, and it doesn't apply
you can use the general language and say, and it includes asbestos, so that you would not be bound from the general provisions of it.
But again, there's lots of pollutants that are litigated in this country under these kinds of insurance companies, and
Maybe you'd want to avoid that.
We do, but...
By being specific, particularly when we are not supposed to give a broad reading to exclusionary policy language.
But I would argue that asbestos is one of the best-known pollutants in this country, and if that doesn't encompass within this definition, what does? With respect to the bad faith...
just to agree with Justice Higgett, asbestos, particularly in the context of property damage litigation, is one of the most common, right?
It is, and especially common in the third-party environmental piece. But with respect to the property section, first-party property, as opposed to third-party, it is one of many pollutants that has been litigated and found to fall within that definition. And we've provided both New York cases interpreting first-party property policies, as well as cases from around the country that have also said asbestos falls within this kind of definition.
Okay.
And with respect to the bad faith piece, just very quickly, we agree that it's duplicative. The Supreme Court found that it's duplicative. In fact, what it says is the bad faith denial of coverage. Well, they're telling us that we breached the contract because we denied coverage. It is duplicative, it's the same thing, and it was rightfully set aside.
Thank you, Counsel.
Very briefly, Your Honors, the belt painting, the Court of Appeals case that was decided in 2003, plaintiffs respectfully submit that that is the controlling case for this issue. Many of the arguments that counsel is asserting essentially is trying to revisit what belt painting already established. The Court of Appeals in belt painting actually went through a long historical analysis of why environmental pollutant exclusion clauses exist. Specifically, they pointed out that during this time period was when there was a lot of regulatory activity that was creating fines and penalties upon a lot of industrialists at this time. So because of that, insurers did not want to cover such penalties. That is the basis for an environmental pollutant exclusion clause. Specifically, the Court of Appeals in the belt painting decision also goes into the fact that a lot of the language that exists within these environmental pollutant exclusion clauses mirrors terms of art that are used in environmental law, specifically terms like dispersal, seepage, and other terms like that, because they are looking at chemical leaks into rivers or air pollutants being dispersed into the environment, not things like asbestos being released during renovations.
Before your time is up, let me ask you about something else. Your claim is based on faulty workmanship and renovation, is it not?
I wouldn't say it is not, Judge. I would say that it is part of the facts that are pleaded, but the claim is based upon asbestos.
You explicitly plead that in your complaint. You say much about that. Yes. Aren't those items specifically excluded from coverage under the policy?
When it comes to the faulty workmanship, I would like to take that into two parts, Your Honor. One is, to the extent that we do plead faulty workmanship, we do not conclusively state that that is the cause of the damages. When we first reported the claim, which is what First Specialty references, we did allege that it was because of faulty workmanship. That was the only knowledge that my client had at the time. That is not what is specifically pleaded conclusively in the amended complaint. The amended complaint states, one second, Judge.
The amended complaint says, does it not, that your property damage was a direct and proximate result of the renovation issues which culminated in the notice of inspection? All SSP entities suffered severe damages, including economic and non-economic losses.
Yes, it does, Your Honor, although we do not state that it is exclusive. Specifically, in addressing that portion of the defendant's...
Why aren't those aspects excluded from coverage under the policy?
Because there is a claw, I call it a clawback provision, Your Honor. I believe there's a more...
It's covered by a cause of loss.
Correct.
So what are the covered causes of loss?
Asbestos, Your Honor. Asbestos is a covered cause of loss under the policy. And so that being the case, it was below...
Although, obviously, we're talking about whether the exclusion of pollutants also excluded the asbestos.
That's correct, Your Honor. The appeals are, in that fashion, somewhat conjoined.
Thank you, Counsel.
Thank you.
Very briefly.
So to sum that up, the plaintiff is out unless he can establish that when you excluded pollutants, it doesn't include asbestos.
I agree completely. And I just want to say about belt painting, that's a third-party liability case. It's not a first-party property case. He goes on and on about rivers and streams
Let me just
and
ask you
things
why we should make that determination on a 3211 motion.
Because we believe, again, that they've pled themselves out of coverage.
Okay.
Thank you for your time, Your Honors.
Thank you. Thank you both.
Can I start?
You may.
Good afternoon, Your Honors. May it please the Court. I am the appellant petitioner, Daron Zanani. I think that this case has been tremendously simplified by virtue of the amended answer and the briefs. I would like to first focus on a couple of points I want to clarify to make sure that I made my point in the brief. One is that the pleadings are been fully briefed and ready to be decided. Between the answer, the amended answer, and the discovery motion, there is really nothing new that anybody is claiming can be added to the record that would justify sending the case back down to Judge Nervo to decide from scratch. And I'm basing my contention on the fact that, to a large extent, the silent respondents have essentially abandoned many of their claims against me by ignoring them in their brief and not even mentioning it. Specifically, the second, third, and fourth, and fifth causes of counterclaims are not even discussed. So the only thing that's really left is the first counterclaim. And I'll get to that later because it's a little bit complicated.
I don't know how much time you have, so what?
I have 5 minutes.
No, I know you do. You have 3 minutes now.
No, 3.
And you
Yeah.
haven't gotten to the point, so
Yeah.
let me just ask you.
Sure.
You know, your main point here is why should this special proceeding not have converted to a plenary action pursuant to CPLR 103C?
Correct. Yes.
So if we agree with that and deem the petition to be a complaint, why should they not have an opportunity to interpose an answer?
They did. They interposed an answer.
Not to the complaint, he responded to a petition.
Well, the petition is going to be the complaint. I'm not going to file a new complaint.
You say that, but that's not what it is. Right now, we have a petition that we're going to deem a complaint. They have an opportunity to respond to that complaint. That's the way it works, right? You don't get summary judgment when issues have not been joined.
I agree. Okay, so it may be that I have a misunderstanding. My understanding of converting an action, of converting a special proceeding to an action, is that the papers in a special proceeding become the pleadings in the action. The court does not, I didn't see anything in the CPLR that authorizes me to serve a new set of pleadings.
No, we deemed the petition itself to be a complaint. You can amend that complaint if you want. You will be within the statutory time to do
I don't think so. I filed a complaint that there was an answer, an amended answer. My 20 days after that has expired.
If it's a
pleading slate is
complaint,
closed.
if it's a complaint requires an answer.
Yes.
An answer is what joins the issues, right?
That's correct, Your Honor. Yes, I agree.
Okay, so if you're going to move for a disposition as a matter of law, I think the other side needs an opportunity to respond to that petition that has now been deemed a complaint.
Okay. I was working on the assumption that the amended answer to my petition would qualify as the amended answer to the petition as if it's converted to a complaint. If the court disagrees with me, obviously, that's correct.
So and this is on the contract claim and the account stated claims.
Yes, and then it's an alternative.
Okay.
The only difference between those two claims is the fact that because of the suddenness of my discharge, I never get a chance to send the last 2 bills of expenses. But otherwise, everything else is exactly the same. And since they don't dispute the reasonableness and appropriateness of those 2 charges, I believe it's appropriate to grant relief to include those 2 expenses.
Okay.
I think my reply brief went through the merits of the counterclaims, the ones that have not been, pursued by the silent respondents. I only have a request, if there is going to be a reversal, I have request that the court consider granting cause because of the accusations made against me, I had to essentially include all my emails with the silers as part of the record, and that was a very substantial expense. It's 1,571 pages. That's the only request I have if there is a reversal.
Thank you, Counsel.
Your Honors.
Henry Cohen for the respondents. You know, the court is absolutely correct procedurally. If now that the case is a plenary action, the very definition of a plenary action is he can move for summary judgment only after issue has been joined. Issue has not been joined. He started this action as a petition. He's now asking that it be converted to a plenary action. Therefore, if the case goes back to the lower court, which it might or should, we then could file an answer, and then he can move for summary judgment. Procedurally, the matter is not ripe for summary
Well, the
judgment.
plenary action, there's also something called discovery, right?
Correct.
So.
Correct. Well, we're going to get to that. There's a lot of issues here regarding malpractice. He's claimed he's worked for my client and he's owed $500,000. There are so many issues of malpractice here. I don't have the time to address all of them, but the primary issue was he was retained in 2008 and was continuous and ongoing till close to 2020 when he was discharged at 21. I'm not going to go into every detail, but essentially he filed a complaint in 2014 based on a handwritten agreement that my client had given him that had the elements of an agreement. That agreement stated that my client was going to get, and again, that's a question of fact as well, what the parties had agreed to, but there was a basic agreement that my client had given them a certain amount of money. He was going to get a certain percentage on the interest in the property on Atlantic Avenue. All that documentation was given to Mr. Zanani. They had been dealing with each other for years. When he drafted the first complaint, he made no mention of any interest in the property or in the entity. All he was asking for was damages and nothing beyond that. Years later, 2017, he suddenly...
Counsel, the details of the merits will be, I mean, you seem to be conceding that a sua sponte dismissal of this proceeding without conversion as required by CPLR 103C was improper. Are you not? You're going to have an opportunity to litigate.
Correct. Yes, yes. I think the court should have just converted it, and then we should have filed an answer and continued the case. What the basis for the court's decision, he was very clear on what the basis for his decision was. But be that as it
Otherwise,
may,
he'd just be starting over again anyhow.
correct. So let it go back to the lower court. We file our answer, and then the plaintiff can proceed as he deems accordingly.
Okay. Thank you, counsel.
Thank you.
I just want to point out that I think one thing to correct is that Mr. Seidler, in his email to me on September 4th, specifically told me that he was going to give me more information in order to negotiate this contract that he wanted supposedly to do, and never gave me anything after that, and that's not in dispute for almost 13 years. So to the extent that there's any claim that I committed malpractice of not negotiating a so-called an agreement, the statute of limitations would bar that, I think. Okay.
Well,
That's about it. Thank you very much, Your Honors.
You got it. Thank you both.
Thank you for your patience and your time.
Maldonado. Sorry, I had to cut that one short because I can see that's going to be a long.
Yeah.
Is that?
You're right, though.
Yeah.
I see my time is up.
Well, see, you showed up before I called you, so, that's what happens. You gotta at least send an email to.
Oh, my God. Email.
Go ahead, counsel, you may proceed.
Thank you. David Tolchin for the plaintiffs' appellants. Putting aside all the clutter, this is a very simple case. The elevator was old. It was falling apart, and it was constantly broken. It required 21 visits in the space of 11 months. The night before the accident, Liberty, the defendant, came and serviced the elevator for 2 hours. and then returned it to service. And the elevator was barely used overnight until the next morning when the plaintiff innocently walked onto the elevator and it crashed as it went up. She
Is
used
there
it as...
anything in the elevator as she gets on it?
Say it again?
Is there anything in the elevator as she gets on it?
I don't know. There was some testimony that there was another cart already in the elevator, but this is a freight
And what
elevator.
did she have with her?
She had a ordinary cart.
Just one or more than one?
She had one, and it was filled with ice in a bag. An ordinary shopping cart like you would see in a supermarket, and it had ice in it, and she just pushed it in and stood there. Well, she had to close the door, and it went up and crashed. When it reached almost the top of the, from almost the top of the little ride, which was just one story.
Sir, do you agree that Espinal controls?
Well, I would say that, I mean, Espinal is a case about the instrumentality. And so, yes, it controls, but also res ipsa loquitur is really the issue.
Well, you have to have a duty first, right?
Sure, they have
got to be a duty, and that duty springs from Espinal, if it springs. And so which aspect of Espinal would be satisfied here to give rise to the duty?
This is they were in exclusive control on maintenance of the elevator. No one else was maintaining that elevator. No one else could maintain that elevator. They went there on a regular basis, like once a month, to do their maintenance, and whenever called. No one else went there to do it. No one else could turn off the elevator. No one else could turn it on. And actually, the plaintiff also relied on them because she walked onto the elevator and thinking
Well, actually, Counsel, was
Yes.
it established that the elevator doors were not within the exclusive control?
The elevator doors, Your Honor, there are two elevator doors. The outer doors on the ground floor and on the first floor, or the basement and the first floor. Then there was the inner door that had a gate. And of course, elevator doors, people walk through them, people use them, but nobody can access the inside fascia plate that's within the shaftway at all, except for the defendants. They were there the night before. They pulled, it says, according to the defendants' theory about how the accident happened, on the way up, it pulled, the elevator header pulled the fascia plate off the wall. Except the elevator fascia plate, they also say, was found to have been pulled down. That can't be. That's not consistent. And only they were inside the elevator at the time, the night before. And they should have seen, and they could not have missed the fact that the fascia plate was loose. It just doesn't.
So you're saying basically, you're contradicting a lot of the witnesses that the defendant introduced with respect to whether they created or exacerbated the condition of the elevator.
Your Honor, all their witnesses.
What is the evidence you introduced in opposition to their witnesses to show that?
All their witnesses copycatted each of their other witnesses. It's the guy who went there afterwards, not even the guy who serviced it the night before.
But your expert didn't even inspect the elevator.
There's nothing to inspect after 2 years after the accident, when the fascia plate had been removed and put back into place. What the expert says is that they should have known, they should have inspected the fascia plate and the headers before the accident. And they shouldn't, if there was a question about vandalism, like they claimed there were vandals that were breaking in and breaking the inside.
Isn't their claim that the elevator would get overloaded, you'd have more than one cart coming on at the same time?
No, not at all.
And that would interfere and misalign the doors?
No. Their claim was that some mystery people would take carts and smashed them into the doors. And by smashing them into the doors, that somehow knocked the doors out of alignment. And the being knocked out of alignment, therefore, pulled the fascia plate off the door when it went up, except the fascia plate pulled down, not up as the elevator went up.
Well, that was the point. They claimed that the cab can only impact the fascia plate if the elevator doors were misaligned. And then there was testimony that the employees, in using that elevator, would, slam into the door, not intentionally necessarily, but that they would slam into the elevator doors, causing those doors to therefore become misaligned.
So may I have a red light? Can I answer your question?
You may.
I'll come back on rebuttal, but I would encourage the court, please, to read these two cases.
Thanks.
The Woolworths case, Wen Yu Cheng versus Woolworth, and also Pavone v. Rudin, and I'll address those later.
Good afternoon, Your Honors. Desiree Berger on behalf of the respondent, Liberty Elevator. I'm just going to briefly respond to a few points that plaintiff made.
The person who actually inspected it and has some expertise about this is Benson, right?
Correct, Your Honor.
And he says that the fascia was pulled off because the door got misaligned.
That is correct, Judge. And what the work ticket and what Mr. Benson specifically testified to is that the fascia plate was ripped from the inner shaftway wall, which only leads the case to that it must have been caused by vandalism or misuse of the equipment. By vandalism, we don't mean that someone's breaking into the supermarket, as a plaintiff is suggesting, but simply the testimony is consistent that these employees were not only using these freight elevators as storage for U-boats, but they were bringing them in and out, banging them into the doors. These are big, underpower pallet jacks used by the supermarket all day long.
There's no one who does or can contradict Benson's explanation of how this happened.
Correct, Judge. And what actually, it's substantiated by not only Benson's testimony, but the affidavit of Douglas Mutart, the president of Liberty Elevator, and the testimony of Peter Stackhouse, who not only has personal experience with the elevators at the AMP, but also consistently testified that the record is complete with vandalism and misuse involving the doors.
Counsel, I'll let you finish that sentence, then I'm going to pose a question. Go ahead.
I just wanted to highlight the fact that not only are there 5 separate incidents within the preceding year of Liberty bringing to the AMP's attention that there are vandalism and misuse of the door occurring, but also in November of 2014, we submitted a proposal to the AMP to replace these doors, and the supermarket ultimately decided not to undergo that replacement.
Now, I know that counsel says that Liberty had exclusive control of the elevator, but wasn't Liberty just required to perform monthly maintenance and to do repairs if notified by, excuse me, the company?
Yes, Your Honor, that is correct.
And they also reserve the right to re-enter. Am I correct about that?
Yes, Judge, that is correct.
But no one has access to that inner door, right, where the fascia is contained.
So the fascia plate is affixed to the inner shaftway. So that is correct, that no one would have access to that specifically without standing on top of the cab and being in the shaft.
And that would include their expert, would it not?
However, the issue here is that the doors were knocked out of place, they were misaligned, and they caught on the fascia and ripped it out of place, which is supported by our work tickets over and over and over. So,
but during Liberty's maintenance, right, could you not have ensured that that plate was properly secured?
Your Honor, pursuant to the contract and industry standard, the fascia plate is not a maintenance component. And we have submitted not only the affidavit, but witness testimony. This is a single piece of steel that is affixed to the inside of the shaftway. It requires no lubrication. It requires no adjustments. The only way that we would have known that anything was wrong is that the elevator would have shut down, which is exactly what happened, and then the supermarket would have called us to respond, which is exactly what happened. We're not in the building 24 hours a day. We don't stand outside of the gates to make sure that it's being used properly by the supermarket. We rely on them to supervise the use of their own equipment, and we will respond accordingly. And we fulfilled our services under the contract by submitting a proposal which ultimately they decided not to approve. I will just reiterate one more point, I'm sorry, Judge. With regards to the res ipsa, there are several cases that I cite to in my brief, including Douglas and Saunders. This particular freight elevator was a manual outer door and an inner manual gate, requiring that each person who wanted to utilize the elevator would have to physically open the doors on both. And the court is consistent that that is not a res ipsa applicable situation. If there's no further questions, I will rely on my brief.
Thank you.
Thank you.
Your Honors, there is absolutely no evidence at all that anyone struck these doors. She said over and over and over again, people were slamming the carts into the doors, not in the record, not ticket after ticket after ticket, as counsel just said. It's not there.
Why wasn't, I thought that the work tickets were introduced. That was part of discovery, was it not?
No, there are like 25 of them, but none of them say anything about smashing carts into doors. There's no testimony in 600 pages of testimony that anyone's ever once saw anyone.
Well, were they asked whether, I mean, I assume that there were depositions taken.
Yes.
Of some of the employees, right?
No, they never did.
Was there any evidence with respect to the work tickets that led Liberty to go into the premises and look at the fascia?
The night before, and Your Honor,
I mean, they claim, for example, that they gave a proposal to the supermarket to replace the fascia.
Yeah, you know what?
Is that in discovery?
Yes, of course, and they did, and that's part of the record. They said, these are old, these are falling apart, you should repair them, you should replace them, but they never said this is because people are smashing.
I thought Stackhouse was the one who stated that something probably impacted the elevator doors.
Probably, Your Honor. Probably,
but Stackhouse,
typically, speculation.
But Stackhouse also apparently advised, or there was Liberty advised Stackhouse of the history of door abuse and
no history of door
abuse to address the elevator equipment.
There was an affidavit put in reply that we had no opportunity to respond to that self-servingly said these all had to do with smashing the doors, but it's not accurate.
Well, Benson said the fascia was dislodged from the cinder block wall.
Yes, yes. A year before, it was dislodged. No, they never said, hey,
but anyhow,
stop smashing the walls. This is very important, Your Honor. They never said.
Which Espinal factor, and I know Judge Higgins asked you the question, but again, so which Espinal factor makes them liable?
They were in control. They were the only ones doing the exclusive control of the repairs and replacement. And Judge Kennedy, they went not only when they were called, they do on a regular monthly basis the preventative maintenance as part of their service contract. It was an exclusive service contract that no one else was there to do.
So repairs had to be authorized by A&P, didn't they?
You mean to let them in the doors?
Other than regular maintenance, if a repair had to be made, A&P had to authorize it.
Yeah, by contract. They're authorized to go and go in and do the doors. They don't need special application or permission or request or anything. This is ordinary preventative maintenance that happens whenever they wish to go.
I was under the impression that prior to the incident that we're discussing, that Liberty had received a number of calls about supermarket employees damaging the elevator doors by striking them with the carts, with the U-bolts. I'm not done. Pellet jacks and dollies. And then if we go back, there was also a work ticket indicating that the elevator had detached the fascia from the cinder block wall.
Yes, that's correct. But that doesn't mean it was caused by anyone, quote, vandalizing it. Now, it's very important that we look at those two cases I mentioned. Your Honor, because it doesn't.
Okay, we'll look at those two cases.
Thank you. Thank you very much.
Thank you. Thank you both. PCT contracting.
May it please the court. My name is Andrew Richards. I represent the appellant respondent PCT. The crux of this case that the lower court completely ignored the terms of the APA.
Your position is based in part on the fact that this was not a material contract with HMC, am I right?
Correct, as defined under the APA.
So why is the contract with Madison in the schedule, in the list and the schedule which appears in section 4.07A?
Okay, the answer to that is it was a signed contract. The unsigned proposals defined in the papers is not a signed contract.
Okay, so what effect is what is the impact upon you of the fact that the arbitrator says that this is a valid contract?
Which is, I'm sorry.
The arbitrator
APA
says you
it's
have
a valid
a contract.
Correct. But the arbitrator did not determine if the unsigned proposal was a material contract under the terms of the APA. That's not an issue in the arbitration. That is of no interest to the arbitrator.
But now that you have this determination by the arbitrator that it is a valid contract, why shouldn't it be considered a material contract?
Because it...
Aren't you stuck with that finding by the arbitrator?
Absolutely not, Your Honor. First of all, the material contract is defined as something that affects the assets or the business of the company. Selling the assets of the company or selling the company is not the business of the company. The business of the company is to install gas mains and services for Con Edison. It has nothing to do, you cannot, what's the word the kids use in my office now? Conflate. They use the word conflate. I never heard that till 5 years ago. You cannot conflate the fact that the arbitrator found an enforceable agreement based on circumstances. Circumstances, not a signed agreement with vis-a-vis Bob Baker and PCT. There was no interest in the arbitrator to say, oh, it's a material contract pursuant to the terms of the APA. That was never decided, so it's really irrelevant. And what's also most important, I want to address something else Your Honor said. The fact that the HMC the Madison 1 contract was listed, besides the fact it was signed, does not provide a waiver of PCT's right that any contract is defined by materiality in the APA. It does not, they don't waive that requirement. It still has to comply with the APA. So the lower court clearly from the decision completely just ignored the APA altogether. Now, I've been before Justice Ostriger for many years. I was dumbfounded. Not one part of his decision even discusses how it's a material contract, except for the fact it was a lot of money. That's not how you determine materiality in the APA. The term materiality in the APA is very specific. It is laid out with terms. And clearly, the unsigned proposal, which became an agreement of some sort 2 years later by an arbitrator based on circumstances between the parties, is not a material contract, as under the APA. An enforceable contract against PCT for Bob Baker? Sure, I can accept that. But it has nothing to do with the determination of whether it's a material contract under the APA. Are there any questions on the material contract before we move on to rely?
You got 15 seconds, so
15 seconds, holy cow. Okay, this is a textbook case for justifiable reliance. There is no way that Riggs could justifiably rely on any statement, whether true or not, that Mr. Persico said. It doesn't matter. That's the whole point of justifiable reliance, is that if you have a reasonable opportunity to figure out what the truth is, you pick up the phone and call somebody who's identified in the agreement, you know you have to pay. The truth of the matter is, they didn't care. Am I done?
You are. Thank you.
May it please the court, I am John Hay.
from Denton's, the attorney for respondent Riggs Disler. As you just heard, the plaintiff's appeal is predicated on its challenge to the court's finding that the HMC contract was a material contract under the APA. The court's finding, however, was supported by overwhelming evidence at the trial, including the language of the APA itself, the testimony of both his client.
Do you see a reading of the APA as it appears on page 289 to page 290, 4.07A to little letter I, that in fact a $50,000 contract would make it a material contract? Because the parentheticals in 4.07A sort of don't line up. There's an open parentheses, but there isn't a closed parentheses, which leaves you a little bit wondering just how to read it. But at the end of the day, little numeral I says if it's over $50,000, it's a material contract, does it not?
It does, and that's exactly our point, that the trial court had the APA obviously before it, and the testimony that was presented by my client and not only agreed with by PCT's client in their testimony was that anything that's affecting the business being the entire company, not just what is being sold, which is what their argument is on appeal, would be a material contract if it's over the $50,000 threshold.
On the other hand, on page 508 of the record, as you look at section 4.22, the intent was obvious that you were to pay the brokerage, and it goes so far as to name Robert Baker, and as it turns out, instead of it becoming Baker, it's HMC, but HMC is really solely owned by Baker. So what justifies Supreme Court's decision in the light of 4.22? And let me just add to that, in a certain sense, the arbitrator, and of course you're going to say it's collateral estoppel, and I'm not questioning that, but the arbitrator's decision doesn't really seem consistent with what section 4.22 says.
The arbitrator's decision was after that 4.22 was signed, so that's, you know, so.
It sort of just seems to the arbitrator seems to have just disregarded 4.22.
I'm not sure it was put before him because that wasn't an issue with the arbitrator. The arbitrator was only looking at the question of the HMC contract and whether that was a binding contract,
Okay,
which
so
he found it was.
So I ask you about 4.22 because of my next question, which is, and I know you have a cross appeal which you haven't addressed, but I will jump to it. And your cross appeal is that you should get attorney's fees, which that gets into a question of interpretation of how you read where you're getting attorney's fees, whether this is a part of the business or not. But is what Justice Ostrager did here was he's stuck with the arbitrator's decision. Plaintiff has to pay the brokerage. 4.22 really called for you to pay the brokerage. So he leaves plaintiff and plaintiff's position, which having paid, not recovering from you for the brokerage, and you don't get your attorney's fees. Sort of a rough justice sort of conclusion to the case.
But it's not a situation where there's.
It's not what you want to hear, but where is that analysis astray?
Well, it's astray because our obligation, my client's obligation, was to negotiate and then pay. It tried to negotiate, it couldn't negotiate because HMC was expecting $1.7 million, where my client was of the view that it wasn't a material contract, it was an obligation to pay, so it was going to be $50,000. So in our complaint, we said, we shouldn't be liable to him for anything above $50,000. But what the judge did that was wrong in trial, and it's the only thing that he did it wrong at trial, was he ignored our absolute right to be paid our attorney's fees, which is a lot more than $50,000 over the course of this case, 2 appeals to this court, including, plus the cost of, we had to take action to get dismissed out of the HMC arbitration in case, because we weren't a party to that, and so we defended our client in that third-party claim and got them out as well. There is, under the contract, a right for us to be indemnified. This is not something where the judge has discretion as to whether or not, it's a prevailing party and I should, have somehow decide who should get paid. That's a right that we have, and
But
the
your
judge.
loss had to arise out of, or be with respect to, or by reason of the breach. And the breach being the failure to list the
Misrepresentation.
misrepresentation.
And also, there are other provisions, including by us being held responsible for excluded liabilities. That's Part C of it as well, and that's...
Were you in any different position as a result of their breach? You still had some negotiations with Barker, right? They didn't bear fruit. They felt
right.
You wanted to give them a certain modest sum, and they felt they were entitled to essentially the 4%, which worked out to well over $1 million. So how did that breach impact you in that regard? You still negotiated with them. It didn't work out, and they went to arbitration, but were you left in any worse position as a result of that particular breach?
As a result of that breach, we faced 2 lawsuits. We were sued by HMC, which we had to get dismissed from, which we were successful in getting dismissed from that arbitration.
But is that as a result of their breach? If they had listed them in the material contracts section,
it would have never come to, if they would have listed them in the material contract, well, they couldn't, if they would have listed them in the material contract section, it was because we would be aware of the 1.7, and the price that we paid for the company would have been significantly different. And that was found by the judge to be the case, that we put in testimony that that was going to happen, and the plaintiff didn't put any testimony in saying that that wouldn't be the case. If they had actually disclosed that, the price would be significantly different. It would have been a lot lower.
Thank you, counsel.
Thank you, Your Honor.
Sorry. Justice Friedman, you had mentioned something earlier. You started with Mr. Hay. It had me a little confused. You're referring to the $50,000 aspect of materiality of contracts or something that had to be disclosed. But it's not just $50,000. There are a lot of things that have to go with it. It has to affect the business. And I still do not see how the unsigned proposal affects the business of gas installation. We're not buying an asset of the debt of Mr. Baker. That makes no sense. This whole case really comes down to common sense. It really is. I mean, the arbitrator had no intent of discussing the APA. Never discussed. Never. They didn't care. It was not part of that part. Now, what's really important is nobody thought that there was a firm agreement of 4%. Mr. Baker sent an email, I believe it was January 17, 2017, to Mr. Gaultier of Riggs, actually the NAPEC, the parent company, where he said, we discussed up to 4%. Now, if you had a contract with somebody of 4%, you would say, I have a deal of 4%. He never sent that. He never sent him the unsigned proposal. He never sent Riggs the unsigned proposal. In addition, Gaultier didn't think they had a contract because he said in an email to Mr. Baker, you don't have a formal agreement. We're not paying you.
Sir, before
nobody thought they had
before
an
your red
agreement.
light goes on, do you want to address your friend's?
I'm sorry, I can't hear you, Your Honor.
Oh,
I'm sorry.
Before your red light goes on, would you mind addressing your friend's counterclaim for the attorney's fees under Section 8.02?
It's not a prevailing party claim. It's just not. It's just not a prevailing party attorney's fees. It's just not. And I really don't think we even need to get there, to be honest with you. I think we're the ones who get the attorney's fees for the underlying attorney's fees for defending against the arbitration.
Thank you, counsel.
Thank you.
To go on with what my colleague said, it is a matter of common sense. And to argue that a $1.7 million brokerage contract is not a material contract because it doesn't affect the business. Of course it affects the business. The business is valued less because it owes $1.7 million. The business of the company is, which is what we're buying their assets and their liabilities, that is affected by the fact that we had to pay it. So of course it was important as a matter of common sense that it's included. And the fact is that their president acknowledged that. He said the business means the entire business. It doesn't just mean the assets that are sold.
Is the operative provision, section 4.07A, what appears after little y, to which seller is a party or by which it is bound in connection with the business or the purchased assets?
Right, so it
says business and purchase.
Business or the assets. Does it have a
not limited? It's not
contract?
limited just to the purchased assets.
No, it's not limited to just the purchase assets. It says that in connection with the business, do you have a contract that you're bound by in connection with the business? Well, a brokerage agreement is a contract that relates to the business, and it also is in connection with the purchased assets because the brokerage contract is about the purchase assets. That's what the brokerage contract is for selling those assets. And that's why it was included within the brokerage contract with Madison, and there's testimony as to this effect. The attorney who put the Madison 1 contract in testified that the reason we did that was because it's the brokerage contract was a material contract. And there was no testimony on the other side rebutting that.
Thank you, Counsel. Thank you both. Ellis?
May it please the court. Jessica Clark on behalf of defendant appellant ABM Industry Groups. ABM has clearly demonstrated that it didn't owe plaintiff a duty of care and that there was no performance or breach of its contract that's implicated here. Therefore, Chase, all of its cross-claims should be dismissed. Chase is the only party that opposed ABM's appeal. The two bases that
Did they not admit that you owe no duty to them? And that the only way that liability will be created will be through one of the Espinal exceptions?
So I believe that Chase is arguing that we did launch a force of harm and that we somehow contractually displaced them, and therefore that we did owe a duty of care to plaintiff, and we're somehow negligent, and therefore that gives rise to contractual indemnity potentially or contribution claims on behalf of Chase. So it's our position that even though these arguments are essentially being raised in opposition for the first time on appeal, they're completely baseless because ABM clearly didn't launch a force of harm. The two reasons that Chase claims we may have launched a force of harm are failures to act or omissions, essentially that ABM should have ordered a 30-yard dumpster, which ABM was not responsible for doing. The only testimony that Chase relies on, which is what the lower court also used in reaching its holding and denying ABM's summary judgment motion, was that of JLL's witness, Mr. Bodner. Mr. Bodner did not start at the building until 2019, which was after the accident, and admitted that he was not familiar with the policies and procedures that were in effect as of 2017. Nevertheless, even if ABM was responsible for ordering 30-yard containers, this has absolutely nothing to do with the accident because the lack of a 30-yard dumpster at the building was not negligent on behalf of any party.
I thought that plaintiff concedes that there was no duty owed to her by ABM. The issue with Chase is whether or not you would be responsible for contractual indemnification, right?
That's right.
And then the argument is because of that dumpster and because you were responsible for the alleged debris on the loading dock, which plaintiff claims that because she's moving the truck or whatever, the hand truck, because of the debris, she doesn't have enough room. So why would you then not be liable, contractually liable?
Because the quote-unquote debris that was there, Chase says we should have removed that debris, these large items. So ABM wasn't responsible for removing large items unless they were requested to do so. ABM only policed and sweeped and mopped as part of their normal contract.
But the question is, are there any issues of fact as to what you're stating, that your responsibility ended in terms of the large dumpster, or ended as to the debris? Are there no issues of fact?
No, in my opinion, there are not. There's nothing to the contrary that Chase has pointed to that said that ABM was requested to remove these large items, that anyone asked them to, that any witness has said that ABM was responsible for removing large items and failed to do so. And even if they were, launching does not rise, failing to do something doesn't rise to launching a force of harm under Espinal. I'll address any further items on my 2-minute rebuttal.
Thank you.
We're not clear on how, Your Honors, would like us to proceed.
I think Rick Distler is the cross appellant. I'm sorry.
Yeah, there's a few.
Yeah, I mean, you have cross appellant JP Morgan Chase.
Okay, I'm happy to go.
No, I'm sorry. You have ABM just went, right? And they are an appellant. Jones Lang is an appellant. So Jones Lang goes.
I'm responding to her, so if you want him to go first, we can just have our argument.
Yeah, but
that's not true. We're responding.
Yeah, let the two appellants go, and then you respond.
May it please the court, my name is Judy Mizell, and I represent the appellant Jones Lang LaSalle Americas Incorporated, sometimes referred to as JLL. JLL was the property manager at the building where the plaintiff's accident occurred. JLL was not the building owner, and JLL did not owe any duty to the plaintiff, which plaintiff conceded in its papers.
Well, the court found that the only duty that you had to plaintiff arose solely out of the contract with Chase, right?
The lower court found that the only Espinal exception that applied was that there's a question of fact as to whether JLL launched a force or instrument of harm because there was no 30-yard dumpster shown in photographs.
But you owe no duty unless one of the Espinal exception comes on, right?
Exactly, correct.
So the only responsibility is to Chase based on the contract that you have.
Correct, but the lower court also did not dismiss the direct claims. So that's why we have to argue from the beginning. So as you said, the only way that JLL would assume a duty was due to one of the Espinal exceptions. The lower court said that there is no detrimental reliance by the plaintiff. There was no comprehensive contract since there were about 5 JP Morgan employees stationed 24/7 in the loading dock. So the only question the lower court found was whether JLL launched a force or instrument of harm. And then the only issue that they really honed in on is the fact—
Or whether you created or exacerbated a dangerous condition.
Absolutely, yes.
Okay.
So the only issue that they really focused on, which was not actually addressed in any of our opposition papers to the summary judgment motion, so we had to first address it on appeal is the absence of the 30-yard dumpster. So there was no 30-yard dumpster in the loading dock, and that's been undisputed when the plaintiff's accident occurred. However, the plaintiff's accident occurred at 5:30 in the morning, and there was testimony from numerous witnesses that the 30-yard dumpster was emptied during those hours of the morning. It was taken from Midtown Manhattan, brought all the way to the Bronx. Then it was brought back. It probably took a couple of hours after it was emptied and cleaned. So the fact that there was no 30-yard dumpster really does not show any negligence by JLL. So JLL, again, as property manager, inspected the loading dock once per month. Otherwise, JLL had contracts with vendors such as...
Your position is it doesn't make out any of the Espinal factors, and therefore you should be, the direct claim against you should be dismissed.
Yes. And also, the cross-claim should be dismissed because since there's no showing of negligence, there's no showing that JLL did anything. There were no actions or inactions. There was no negligence as to the inspections that were done.
No common law indemnification, but you are in, are you not, on potential contractual?
Yes, we are.
Right, so
But-
you're in the same stat as ABM.
Yes, we are.
Okay.
And according to our contract with JP Morgan, there's mutual indemnification as to both parties, and there needs to be a showing of negligence in order for that to be triggered. So that's why I go through all of these aspects of Espinal to show that there's no showing of negligence, and if there's any showing by any party, it would be that there was negligence by JP Morgan for not contacting someone to have items removed because there were 5 people stationed 24 hours a day, 7 days a week. So that's why on
The Chase security guard was in charge of the loading dock. Wasn't that person?
Yes, that would be the dock master was in charge. And multiple JP Morgan witnesses said they were responsible for maintaining the loading dock, they were responsible for safety. They would contact JLL
Was that
or
Roden
ABM.
who in fact didn't allow the plaintiff to unload using the truck's lift gate?
That would be JP Morgan who, yes, JLL was not in the loading dock at any time that this accident occurred. There's no evidence, at least, of that. Nor was JLL ever in the loading dock other than when they were doing inspections and sometimes on occasion would pop in.
Okay.
If I may, I also just wanted to...
I'll give you 20 seconds.
Okay.
Last case.
We also had to, we also appealed the lower court decision regarding the third-party action because Empire Office, which was a contractor that...
Well, Empire was doing the janitorials?
They were not the janitorial company. They did carpentry, masonry, and some construction. Their witnesses testified that they would retrieve items from the loading dock. They would dispose of items in the loading dock.
They didn't get rid of their debris from the loading dock, isn't that so?
There was testimony from Mr. Granton that they would remove their items into the dumpsters in the loading dock. And then the dock master, Miss Roden, said that she observed them putting things in the dumpsters too. So our position is if there's a question of fact as to JLL's negligence, there should be a question of fact as to whether Empire Office launched a force of instrument of harm as well.
Thank you, counsel.
Thank you.
Now Chase gets to answer. No?
Did you want, Your Honor, Empire to go? Because I believe it's a short response, and then Chase can go. I'm happy to do it.
Okay, then let Chase get the last crack. I mean, however you want to do it. I stopped being the manager. It's the last case of the day. So you want to go first? Go. So you're with Chase.
No, I'm with Empire.
Empire,
I'm the
okay.
third-party defendant, okay? So,
So
please,
Jones
the
Lang
court.
just spoke about you, right? About Empire.
Correct.
Okay.
At the end was the Empire discussion, correct. James Strauss, may it please the court. Thank you, Your Honors. I know it's been a long day for everybody.
So the record showed that Empire did place some items on the loading dock, right?
That's incorrect.
Okay.
The testimony is unequivocal from Mr. Granton and Mr. Fagan that every time they had any debris, whether it was furniture, anything, they put it into a dumpster, or if the dumpster was...
But that's not what plaintiff said, right?
No, plaintiff had no knowledge.
I thought there was some testimony that they saw Empire placing items on the loading dock.
Yeah, but plaintiff at the motion court talked about materials on the loading dock being placed by Empire.
I think that's a reference to Miss Roden, who was a Chase person. The plaintiff certainly.
What does the record at 3004 say?
I don't have it in front of me, but
Well, does it really matter whether it's plaintiff or whether it was Chase's person, Ms. Roden? Does it matter who stated it?
It does matter, because what Ms. Roden ultimately said in her testimony was that she did not know if Empire or Logistics ever left furniture on the loading dock.
And the plaintiff's not going to know.
Correct. Plaintiff just
Plaintiff
pulled her
delivering
pallet
one
jack.
day is not going to know what Empire, who is the
Of
construction.
course. So it couldn't have been from plaintiff. It had to be from Ms. Roden, which is cited in plaintiff's brief and Jones Lang's brief and my brief. What Ms. Roden said is that I think I saw Empire or Logistics sometimes putting stuff down here. But her testimony was really, if you parse it out, and it's all in my brief, she said she did not know if Empire or Logistics ever left furniture on the loading dock. That's at record 600. She stated that she never recalled Empire leaving furniture on the loading dock. Again, that's record 578.
So Cancela testified that the materials depicted in the photograph were placed on the loading dock by Chase subcontractors, but did not name any specific contractor.
Correct.
Roden, who's the dock master, saw the workers from Empire bringing furniture on the dock.
That's what she said.
But she did not know. Right, that's what she said.
She did not know, but she said she did not know.
She did not know when that occurred, but she did know.
She said she admitted that she did not know if she ever saw an Empire employee on the loading dock. That's at 575. And she testified when she saw the pictures of the materials on the loading dock into which Miss Ellis crashed, she did not know if any of those objects in the pictures belonged to Empire. I don't dispute that there was plenty of material that Miss Ellis crashed into. The testimony of Mr. Granton, the testimony of Mr. Fagan, those are the witnesses from Empire and Logistics, specifically said any materials that we had, that we brought down to the loading dock, went into a dumpster, and if there was no dumpster available or it was too filled, we personally hired somebody to cart the stuff away. There's absolutely not a scintilla of evidence that links Empire or Logistics to any of the materials that Miss Ellis crashed into. And that's the fundamental issue here. Not a single kernel of evidence can show that we had anything to do with what she crashed into. And that's why we got dismissed from...
So you wanted affirmance because you're out of the case at this point.
Correct. We were the only ones that got out of the case. And we were appropriately so. Justice Leibovitz determined, number one, we didn't put anything on the loading dock. And number two, we had no obligation to remediate the loading dock. There were no work orders, which if we had a contract with Jones Lang, and if they wanted us to remediate the loading dock, they would have had to give us a work order. Mr. Bodner testified specifically in January of 2017, we found no work orders relating to Empire. Simply stated, there's just no evidence to establish that we had anything to do with the materials that she crashed into. So I ask that there's an affirmance. And lastly, I will say that I note Justice Leibovitz did grant us costs in connection with this matter, and we would ask for costs as well in respect to this appeal. Thank you.
Don't forget your mask.
Okay, Chase.
May it please the court, Thomas Stagg for JP Morgan Chase and 383 Madison. I think it would be helpful, Your Honors, if I provide a little bit of context, because I think there's some confusion as to who did what, who is responsible for what, and how the various contracts were structured. While I understand why JLL would like to minimize its role and ABM would like to minimize its role at the building, there is a 164-page document called a Master Services Agreement. This document is the Bible. It provides for all facilities management and other services contracted between JP Morgan Chase and JLL, Jones Lang LaSalle.
Yeah, but what does that describe what their duty is?
It does, Your Honor.
To plaintiff absent Espinal?
Well, it's I think that's the tail wagging the dog, with all due respect. The the dog here is what are the scope of services that are required by, whether it's common law or under the contract, I'll deal with the contract, required by JLL. JLL displaced Chase. This is a massive contract for hundreds of properties throughout the Northeast. Office buildings, 383 Madison is a 47-story office building. Like most office buildings and skyscrapers in Manhattan, it has a loading dock. That loading dock has security guards who are stationed there. All of the employees that have been referenced in argument today and below were security guards stationed at the dock. LaToya Roden, the dock master, works for the security team. Everybody else is a JLL employee or an ABM employee. Chase does not pick up garbage at that building. JLL is contracted to pick up garbage under the Master Services Agreement. We call it the MSA. And in turn, delegated that contractually.
That's a contractual responsibility to you, not to plaintiff.
I understand, Your Honor. So at the end of the day, though, if it's JLL's responsibility, ultimately it's their responsibility because they're contracted. I can point out the provisions in the contract, in the MSA, in the record that deal with their scope of services. They're responsible for ensuring that that dock is clean, ensuring that that rubbish is taken care of. Are there Chase employees there? Yes, but that doesn't mean that they took on responsibility, contractual responsibility for cleaning that dock. They didn't. And nor does it mean that they took on responsibility, for maintaining the dock leveler. There's a little confusion as to what the definition of a lift gate and a dock leveler. A lift gate's on the back of the Cisco truck that plaintiff was driving. The dock leveler is on the dock, and that was used to meet the bed of the truck or a lift gate. Plaintiff's testimony here is there's an allegation that the dock leveler was defective. We retained an expert, an architect who inspected it. There is no doubt, there's no evidence indicating that in fact it was defective. On the contrary, it was working perfectly fine. That's what JLL was responsible for maintaining once a month.
But you prevailed on that, right? I thought the Supreme Court declined to dismiss the cross claims that you had against Jones, Lang, and ABM.
That is correct.
For common law and contractual indemnification.
That is correct, Your Honor.
So you still have that on? You folks are going to nuke it out on that. The question is whether there was any liability to plaintiff.
And that goes to the Espinal exception.
Right.
And I'll back into
and whether
that.
there was any negligence on the part of ABM that would then...
There were, Your Honor. So if you look
at... the tribal issues of fact, I would suggest, but I can understand why you say there is negligence.
I'm saying that Espinal, the first exemption, applies here because JLL and its subcontractor, ABM, completely displaced Chase with respect to cleaning and handling that dock, not security. It's specifically in the record.
So why was there a Chase employee giving orders to plaintiff about how to use that facility?
Because, Your Honor, and if we go to the plaintiff's testimony on this, and that's on the record at 3215, the claim here is that Chase told her that she couldn't use her lift gate. That's not what she testified to. I went through her testimony thoroughly. What she was told is that she has to use the dock leveler. Why does she have to use the dock leveler?
So there's a misunderstanding between plaintiff about what a Chase employee told her.
But it's
there's
relevant.
A question as to whether there was total displacement or not.
There's not, because the reason a dock leveler must be used is because that bridges the gap, Your Honor, between the truck.
No, listen, I'm not an expert, but that's what trials are for.
But I understand, but I'm trying to say that just because a security guard made a statement to plaintiff doesn't displace the responsibility that JLL...
If a Chase employee tells plaintiff how to do her job or how to unload or load up, you have a responsibility.
That's not what she said. That's what I'm trying to say. She didn't testify to that.
I'm sure
she
the
said
jury will be able to parse all of that
You know,
out.
counsel, the thing is, I was on that first case, and I believe that that was what she stated.
She said, she never said that she couldn't use that her
She
lip.
was told that she had to use other equipment.
She was told she had to use the dock leveler, Your Honor.
Right.
And that's true, because every truck that comes in has to use the dock leveler.
Okay, so she did it and got hurt pursuant to instructions that your employee gave her.
That's not why she got hurt, and that's what I tried to
That's
say.
what she's,
Good luck with the jury.
I
That's the whole point.
that was her claim, is that that's why she got hurt, because it got stuck or something, and you know, it fell, and she was injured. That was my recollection.
But it got
anyhow.
stuck on her truck, Your Honor, the lip of her truck. The documents, she took before and after photos. She documented her claim before and after.
We got you, counsel.
Thank you.
Thank you.
Your Honors, I just want to quickly address that we are appealing to have dismissal of Chase's cross-claim for contractual indemnity as well, because we believe that ABM's scope of work is completely unrelated to the cause of plaintiff's accident here. And I just want to be very clear
You think we
about
can
that.
determine the cause of plaintiff's accident as a matter of law?
Well, I think that she,
Or that it wasn't in violation of the contract you have with Chase?
I believe that ABM's scope of work, yes, because I believe that there's sworn testimony that from ABM's witness, there's no contradictory testimony that ABM was not responsible for removing those particular items. When ABM's witness looked at the items involved in plaintiff's accident, he said, those are items that would have required a special request, and there would have been a written document. Those are not something that would have been ordinarily just removed during the course of ABM's policing. Nobody from Chase or anyone else contradicted that testimony. It's not part of ABM's ordinary contractual responsibility. So to say that ABM was responsible for just removing that,
There's no evidence with respect to concerning your failure to clear the loading dock or order a dumpster with, you don't think that that creates an issue of fact?
I don't think there's any evidence to show that we didn't do those things. There's nothing, the only witness who said that we ordered dumpsters also along with JLL is a witness who started in 2019. So I just think that there's absolutely no nexus to ABM's contract and what happened to plaintiff. So, I just would also say that, Chase's witness admitted actual notice of the condition and that they cannot be indemnified for their own negligence. So that's it. Thank you, Your Honors.
So you got 2 minutes, Gross Appellate.
I have Jones Lang LaSalle, the appellant, respondent to third-party defendant. I just want to reiterate the responsibilities of all the parties, because I know that there's a lot of people coming up and down from here. JLL was the property manager. JLL inspected the loading dock once per month, and then JLL was given work orders electronically when there were work to be done in the loading dock. For instance, multiple witnesses testified. If we wanted the upper loading dock cleared of all of these furniture items.
You're the facilities manager, you hire Empire and you hire ABM.
Yes. We were not their supervisor, though, and no witness said that we
I
supervised
got
them.
They both subcontractors.
We were
Familiar
hired
with
to,
that.
yes. So yes, they were subcontractors. We were not supervising any of these witnesses. That's uncontradicted. ABM had a porter there 2 times a day. JP Morgan had 5 people there 24 hours a day. Empire office was going up and down, retrieving items, disposing of items. JLL did not have an office in the loading dock. JLL had an office on another floor. They may have popped in some days to say hello, see if JP Morgan needed anything, but that's really what JLL's role is for the loading dock. JLL had the master service agreement so that they can make these contracts with the janitorial company, with the carpenters, with other companies. That's not disputed. But there's just no negligence that can be found based on what JLL did in the loading dock. There was no evidence that the absence of a 30-yarder was because JLL did anything wrong. There was no work order that showed, we were asked to do something and we failed to do it. There was no inspection record that was disclosed that showed we found something wrong in the loading dock and we failed to do it. So for that reason, I rest on my brief.
Thank you.
Thank you.
Thank you all. Huh?
He had,
Oh, Chase, oh, yeah, I'm sorry.
Your Honor.
You do have 2 minutes. I forgot the cross appeal, sorry.
No worries. I'll be very quick. I would just call the court's attention to the master services agreement, specifically pages 1653. That sets forth the specific loading dock requirements that JLL has to Chase. I know there was an argument made that I believe JLL argued that that only applies to outdoor structures. However, there's a reference to a basement there, which is obviously not responsibility for a basement. And it specifically says, page 1654, that JLL is responsible to maintain loading docks and keep dock areas free of trash, pests, and natural debris. The other thing, too, to understand this master services agreement, it's important to look at the specific language. At page 1616, it specifically says, and I quote, Your Honors, supplier, that's JLL, shall provide overall management of the multiple services required to provide JPMC with fully functional facilities. And there's a scope of responsibility that lists everything that JLL is responsible for: electrical, building, mechanical, and HVAC, building control systems, cleaning, including day porter services. JLL was responsible for the relationship with the landlord. They're responsible for the relationship with the tenants. They hired ABM. They were responsible for dealing with Empire. Chase had absolutely no dealings with those subcontractors, didn't coordinate with them, coordinated only with JLL. But it was JLL that took on the cleaning responsibilities. There's no dispute that Chase had security. It's in the contract. JLL wasn't responsible for food, wasn't responsible for things like security. That was Chase's responsibility. So I just want to make sure the court is clear that the context here is that it's a massive contract that applies to multiple properties and 47 stories of this building, which were in JLL's control.
Thank you all.